Good morning, everybody. Happy Monday. Welcome to TCF Live. I am Dan Soul. I will guide you on a 3-hour journey through Courtlandia, starting with one of our favorite magistrates, Magistrate Chisholm.
Start with Ahmad Imbrough. Morning. This is citation 26RO03409. Mr. Imbrough, you were cited for driving on expired plates back on the 19th of May. When did you get the new plates or tabs?
It was the following week. Here it says I think May 20th, 2026.
What are you reading from, sir?
Sorry?
What are you reading from?
I'm reading from the
registration.
sticker.
Yeah. It actually shows 520.
Yeah.
Right. Okay, so when you were driving, the plates were expired.
Yeah.
Is there a motion, officer?
Motion to dismiss, magistrate.
Mr. Imbrough, thanks to the officer's motion, the ticket is dismissed.
Okay.
You are good to go, sir.
All right. Thanks. Goodbye.
Bye-bye. This is citation 26RO01641.
Yes.
Today, you were cited for driving the wrong way on a one-way street, center near 4th. This is alleged to have occurred on March 24th at 7:30 in the evening. Are you here to admit or to deny responsibility or to admit with an explanation?
Yes.
Yes.
Yeah, I got a constriction nearby street. I got a pickups one way. I didn't know his way is the wrong way. After that, the policeman he said it's
It was a one-way. You didn't know which way was the wrong way.
because I got a little constriction nearby the street.
I'm sorry, sir. I missed what you said last. I can't tell you that I understood what you last said.
Oh, okay.
If you'd repeat it, please.
Yes. I drive the wrong way, right? But I got a little constriction nearby the street. I pick up the wrong way, but I apologize for this.
And that's $150, which can be paid online or by mail or at the counter in the courthouse, whatever you prefer.
Yes, but I need to apologize for the point.
Well, the points don't come from the court. Court has nothing to do with the point system. The points come from the Secretary of State. Your record is such that you may be eligible.
Okay.
You're not.
Yeah.
You're not eligible.
How much do I pay?
Say again?
How much do I pay?
$150, and you can pay it today.
Okay.
Okay, so if you go down to the counter, you were in the courthouse, correct?
Yes.
Yeah. When you go downstairs, just step to the counter and you can pay the ticket there, sir.
I want to pay by tomorrow.
Why don't you pay it today?
He got the money. My money, he got the money today. I got the money for tomorrow.
But you will have money tomorrow?
Yeah.
Okay, that won't be a problem.
All right.
So you're all set. If you give the device back to the court officer, please.
Okay.
Thank you.
All right.
This is citation 26 RO 03114. Ms. Boden, you were cited on the 10th of May, about midnight in the area of 11 Mile and Campbell for disobeying a traffic signal. You can admit, you can deny, or you can admit responsibility with an explanation. How do you wish to proceed?
I'm sorry, can you repeat it one more time?
Did you run the light or not?
No.
You know, the
I
officer has the film.
Well, I didn't mean to run the light. It was turning yellow in the mist when I was still going, but
What does a solid yellow light mean?
slow down or stop completely.
No, flashing means slow down, caution. Solid means stop.
Okay.
It doesn't mean to try to get across before it turns red. So are you here to admit or to deny responsibility?
Admit.
As I'm looking at your record, it appears that you're still eligible for the Secretary of State's once-in-a-lifetime opportunity to take a traffic safety class to stop the points from going onto your record. The ticket you got at the end of 24, you didn't show up or take the class, so you still got that available to you. So the Secretary of State is going to send you a letter to tell you how you can stop these points from going onto your record. Do you still live on Strathmore?
Yes.
Yeah, that's the address to which the Secretary of State is going to send the letter. And so the next letter you get from the Secretary of State is good news, not bad news.
Okay.
And the fine on this is $150, which can be paid online or by mail.
Okay.
Are you in the courthouse?
No.
No. Well, you can pay that online or by mail, and you're good to go. And the Secretary of State is going to tell you how to stop the points from going onto your record.
Okay.
Good luck to you. Ms. Flynn? This is citation 26 RO 01639. Ms. Flynn, you were cited for driving on expired plates on March 24th. When did you get the new plates or tabs?
I'm sorry, say that again?
When did you get the new plates or tabs?
Probably the 25th, the next
Do you
day.
have the new registration with you?
No, it's in the car that I was driving that day.
Do you have the receipt with you?
No, because my husband took care of that. I mean, no, I didn't know that I was supposed to bring that with me.
Okay, we can skip your matter. Can you get it out of the car and bring it back to the camera?
I'm sorry, say that again?
What we'll do is we can put you back in the waiting room and you can go get the new
It's
registration, if you would.
It's at my home. I'm at work right now. I'm driving a different car.
Okay, can you
I can check to see if somebody's awake at my house and they can take a picture of it.
or you could do it tomorrow.
Okay, do you want me to email it to you?
No, I think if you just come online
Okay. Oh,
and
tomorrow morning I'm in all day meetings.
okay,
Starting
do
at
it in the afternoon
7:40.
tomorrow between 2 and 4.
I'm in from 7:45 until 5 p.m. Let me see if I can't get a hold of somebody, and I didn't realize I would they were able to
We
look
need
it
to know
up
when it was renewed.
They were renewed the day after.
Right, but we need to see it.
Okay. Let me check to see if
Okay, we'll come back to you in a little bit.
Okay.
Daryl Howell. This is citation 26 R 03105. Mr. Howell, you were cited on May 9th, about 9:30 in the evening for driving on expired plates. When did you get the new plates or tabs?
It was within the next week.
Okay, do you have the new registration with you?
Yes.
Can you put that in front of the camera, please? And then if you speak, the sound of your voice will make the camera focus on you and we can read it. If you would say something, please, sir.
You want me to say?
I want you to put the camera or put the registration in front of the camera so we can read it. And then if you would speak, the camera will focus on the sound of your voice and we can read it. But we can't read it if you don't say anything.
But what do you want me to say?
Hello? It really doesn't matter. Just make a noise.
Sorry, it's a little blurry here.
Magistrate, I do see that it is updated.
Okay. Do you have a motion?
Motion to dismiss, please.
Okay. Mr. Howell, you were good to go. Thanks to the officer's motion, the ticket is dismissed.
Okay, thank you.
Thank you.
I was going to move on from this court, but I'm going to stick here for a few more minutes because it's hilarious. What do you want me to say? Oh, good Lord. Good morning, everybody. It's good to laugh.
Something has come online from an iPhone. Your screen name is iPhone. What is your name?
My name is Chek.
What is your name?
Chek Javer.
You were ticketed in file number 26 R02773A and 2773 even. You get two tickets back on the 29th of April, about 8:20 in the evening. The tickets were issued on Woodward near Normandy. One ticket was a waivable ticket for having a cracked windshield. The other ticket was an object hanging from the rear view mirror. Have you had the windshield replaced or repaired? Mr. Javar, did you fix the windshield?
No.
No?
What? Sorry.
Did you replace the windshield or have it fixed?
Fix for window.
You got a ticket for having a cracked windshield. Is it still cracked?
Yeah, it's correct. Yeah.
And you're still driving it?
Yeah.
Then you got a ticket for having something hanging from the rear view mirror. What was hanging from the rear view mirror, sir?
I'm so sorry for sir, my Dutch. My English is no.
Okay, but what was hanging from your mirror when you got the ticket?
It's Royal Walk and Royal Walk.
Mr. Putz, were you able to tell what he said?
No,
Can you-
magistrate.
What was hanging from the mirror, sir?
Can you please traduction Arabic or no?
Say what?
Traduction Arabic because my English is It's bad. I'm not speaking English very good.
Can you get a language line? Okay, we're going to put you back in the waiting room while we get a translator online. We are going to get a translator. It'll just take a few minutes.
What language? I'm sorry.
Arabic.
Awesome.
Ms. Flynn, do you have any luck?
Yes, I do. So I have one, I was able to find the registration online, and two, I have a picture of my tab.
Okay, if you would read the first 8 digits on the bottom left-hand corner of the registration.
Okay, 1 second. It's still downloading. So 1 second. It's still doing this.
Dial phone, please. It is 646-876.
Any luck?
We're 44th District Court Magistrate Chisholm.
What is it doing now, ma'am? Ms. Flynn?
It's still downloading.
No.
It says it takes up to 3. The reference number is 2026-0622-14696, but that hasn't completely downloaded.
Okay, can I ask you to repeat that number again? It was 2026.
0622-14696. It's almost done downloading.
That's June 22nd.
Correct.
Well, that's today.
Yeah. Well, that's just the reference number.
Right.
That's on. Yeah.
That's-
It's very close.
There it goes. You got it?
Still. Okay. Now I have to pay an access fee. I have to pay $1 to get this, so 1 second. I have to get it card out.
But before you do you remember how soon it was
It was the
after
day
you got the ticket?
I was pulled over. I believe I was stopped on a Wednesday. It was the day after because it was my husband went and got him.
Counselor Plitz, do you have a motion based on this?
Magistrate, motion to dismiss, please.
Ms. Flynn, you were good to go. Thanks to the
Okay,
officer's
thank
motion,
you.
the ticket is dismissed.
Okay, thank you.
I love it. Please, magistrate, dismiss this, says the cop. Oh my goodness. Good morning once again, everybody. It's TCF Live on a Monday. Let's move from the ridiculousness to the bad language. Lake County, Ohio, Judge O'Donnell.
State of Ohio versus Brandon Gill, case number 26 CR 0000595, set today for an arraignment. The defendant is present with counsel, Mr. Reardon. An 8-count indictment has been filed against the defendant in this matter. His bond was initially set at $2 million by the Willoughby Municipal Court. The state will be asking that that be continued today. Thank you.
All right, Mr. Reardon.
Thank you, Your Honor. Mr. Gill and I have both received a copy of the indictment. He and I have reviewed it. We would waive any reading of it. We'd enter a plea of not guilty to all the charges. and would ask that we be heard on the issue of bond.
I'm not guilty, plea will be entered. Go ahead.
Thank you, Your Honor. I had filed a motion, which I know the court has a copy of it, and in the motion I stated the reasons why I think Mr. Gill's bond should be reduced, including that he has no prior criminal history, he lives locally, he has a family, supports him, he has the ability to work. So I would ask the court to consider a reduction to a reasonable amount, which of course we'd have no objection to a GPS if the court thought that that would be necessary as well. So I'd ask the court to consider a reduction in the neighborhood of 100,000 or so we'd have a chance to at least post.
All right, the bond will remain at $2 million cash or surety, no contact with juveniles, no electronic devices.
That's it.
Thank you, Your Honor.
I'll be in touch. All right. Yep. Thanks. Yep. Yep. Jesus. Wait. Yep.
Mr. Downey.
Thank you, Your Honor. This is case number 26 CR 186, State of Ohio versus Michael R. Chappelle. This is defendant is present here with Attorney Anthony Vondra. We are here for an in-court arraignment. Defendant was indicted in a 4-count indictment by the Lake County Grand Jury for possession of drugs, OVI, and other related charges based upon an incident that occurred back on February 6th. We're here for an in-court arraignment, I believe, to address bond, to give the court a background here. Originally, he appeared for his initial appearance at municipal court. Bond was set at personal recognizance. His case was bound over on February 17th. At that time, the defendant tested positive and his bond was revoked. He then sat in jail for a number of weeks. He was then released on own recognizance based upon agreement with the state and defense counsel on March 17th. While he was out on bond on own recognizance, he picked up a new charge for aggravated menacing, which my understanding has been resolved now in Painesville Muni Court as of last week. He also picked up a new charge for vandalism, a felony charge based upon some conduct that occurred while he was in our jail. And that charge has been bound over as well and is headed on its way here. So the question now, I guess, is whether or not his OR bond will get reinstated, and nothing else from the state at this time.
All right, Mr. Vondra.
Thank you, Judge. May it please the court. Certainly, we'll acknowledge receipt of the indictment in excess of 24 hours, waive its reading this morning. Respectfully enter a plea of not guilty, and I'd like to be heard on the issue of bond.
All right, not guilty, plea will be entered. Go ahead.
Judge, on this particular matter, it has a series of hills and valleys. Mr. Chappelle was in jail February 6th. He was released from medical care February 7th. As a result of testing positive in the municipal court, he was back in jail on the 17th for about 5 weeks. It's at that time that apparently this vandalism charge arose. It wasn't charged until June 2nd when we received a copy of it when we were in court on the 16th. He was involved in a matter at the Bob's Towing. We resolved that matter, as the prosecutor indicated, to an M4 menacing wherein he received a $250 fine, 30 days suspended, as well as 1 year of probation. And we had provided the court with a motion to recall the warrants and reinstate his original bond, personal bond, on the matter involving missing the arraignment on June 12th. And we provided documentation that he was in a rehab center at that time, Your Honor. So we would be asking for a reinstatement of the original personal bond in this matter.
All right, I'm going to restate the own recognizance bond. You're not permitted to drive, and don't pick up any more new cases. Okay, if you fail to appear on this OR bond, you'll be charged with a new felony 4. You understand that?
Yes, sir.
All right, anything further, Mr. Downey?
No, Your Honor, thank you.
Vondra?
No, Your Honor, thank you.
Alrighty, everybody, it's TCF Live on a Monday. Good to have you all with me. Let's go to Michigan, Huron County, Judge Prull.
57242FH, Time of day sentencing on probation violation. The defendant is present, represented by Attorney Zachary Blaza. People are represented by Prosecuting Attorney Timothy J. Rukowski. On May 11th of this year, the defendant entered a guilty plea to violation of probation, and probation violation report has been prepared by Mr. Nathan Licht. It's dated May 12, 2026. Mr. Blaza, have you and your client had the opportunity to review the updated report?
We have, Your Honor.
Any additions, deletions, corrections, or objections?
The only addition that it would make, there are no corrections to be noted, but just by way of update, it notes that he hadn't completed the alcohol class. He has at this point completed the alcohol class. If you have that certificate that he provided to you.
Okay, we'll note that in the report as well.
Thank you. Just so the court understands, he hadn't had that scheduled for several months, and it was actually canceled by the program because they didn't have enough participants. So that's why it's really coming in here late in the game. But it certainly could have been done earlier.
Understand. Also, there is a sentencing memorandum that the court reviewed as well.
Yes.
In this matter. Do you agree with all that, Mr. Slabaugh, regarding the report?
Yes, sir.
No additions, deletions, or corrections other than what Mr. Blaze has stated?
No, yeah.
Mr. Rukowski, any objections to the report?
No, Your Honor.
Thank you. Mr. Blaze, anything you'd like to say on behalf of your client?
Absolutely. So as the court noted, I did submit a sentencing memorandum, providing the substance of my argument. And I'm frustrated. I'm sure the court's frustrated as well. My argument is very similar to what we said the first time we were here. While I always appreciate when my clients hire me again, I'm not in the type of business where I necessarily want to see clients over and over again. And Brendan's one of those clients. I think our first case was resolved in a way that was certainly beneficial to him. I think it was appropriate. I think justice was served. And through that sentence, there was a punitive measure initially with some jail time, allowed to serve on the weekends, allowed to keep his job. He went through rehabilitation. Of course, had the first probation violation, a little more jail time that time, but still kept on HYTA status, and here we are again. And like I said, I'm sure the court's frustrated. I think at base, though, of course, the sentence has to do with rehabilitation and punishment. And as noted in my memorandum, he has completed sex offender therapy. The discharge from that program noted it was done with improvement. He complied with everything. Of course, his legal troubles subsequent to have nothing to do with sex offenses. So I think from the first sentence, that rehabilitation was successful in that sense. But obviously what we have here is an issue with respect for the law, respect for the court sentence, with Mr. Slabaugh having come before this court twice now with OWI offenses. With the second offense, he's entered a plea, admitted responsibility in that. He's due for sentencing in Sanilac in the coming weeks. I certainly think the court would be well within reason and would be appropriate to impose a punitive sentence. And that punitive sentence necessarily might need to be more severe than the last. But I think that removing him from HYTA, I think would be too punitive, to put it frankly. That's not just a limited sentence of months or even a year and a half, which is being recommended here by the probation department as far as incarceration. That would be a lifelong punitive sentence. It would be a sentence of stigma for the rest of his life. I think that that would be a step too far, in my opinion. Certainly well within the court's ability to do that, but I would ask the court not to do that. If he needs to be incarcerated to really send a strong message, then by all means, then I think the court should do that. But I would hope, and I know what he would hope, that he would be able to remain on HYTA status so that he can come back from this, do what time he has to do, get alcohol treatment, and get that issue under control. Seemingly, that is the issue that remains. The sex offense issue, I think, has been addressed, and I don't foresee that as being a problem in the future. So I would ask the court to not follow the recommendation of PSI, sentence him to whatever punitive term he finds necessary, but to leave him on HYTA status so that he can continue to receive the benefits of that status.
Thank you. Does your client wish to address the court?
Yes.
Slabaugh, go ahead, sir.
I would like to say that I understand what I did was wrong. I take full accountability for my actions. And I understand I have an alcohol problem. I never meant to disrespect the court or I apologize. I just hope that you can give me what you see fit and I can look past it.
You're welcome. Mr. Rutkowski, anything you have?
Your Honor, I would point out to the court sentences a lot of individuals to HYTA and gives them that opportunity to not have a criminal record. And at times we'll get people that will come back and the court will revoke the HYTA on the first violation. The court didn't do that in this case. The court also looked at the circumstances and said, well, we'll give you another chance. But the end result is that he has two new criminal offenses while on HYTA. The first time the court initially, when he gave Mr. Slabaugh HYTA, said 16 days in jail, can be served on the weekends, even working with him because he had a job at the time. And then he picks up this violation, so the court gives him 60 days. And then from there, after he does his 60 days, now he picks up another offense. The bottom line is that it's not, the probation through HYTA doesn't say no sex offenses. It says no violations of the law. And he violated the law not once, but twice. And because of that, I believe that that is based on what the recommendation was from Agent Lick. We ask you follow the recommendations. I would point out that the recommendations are at the lowest end of the guidelines too.
A lot of times in criminal cases, there's always one side of the story. One side of the story typically is, well, you do the crime, you do the time. This is a violent crime, or this is a heinous crime, this is a terrible crime, and you have to be held accountable for it. And we understand that. The court understands that. It happens every day. But there's another side to the story as well. The other side to the story is maybe it's a youthful offender. Maybe he was or she was in a situation where the collective thought process was gone and you were just acting, whether it be on impulse or because of substances or just flat out just, for lack of a better phrase and no disrespect, brain dead. It happens. People make mistakes. And this court, along with other courts around the state, have been giving individuals opportunities to better themselves. And, you know, no one wants to be known as the hanging court or the strict court or this. Every case is different. Every single one is different. And the idea is to impose a sentence that not only sends a message, but looks at rehabilitation, looks at other factors to come up with something where at the end of the day, you learn from it, you move on from it, and you never do it again. And the underlying offense here is significant. And we have a very young man in front of the court. And so there are times that in cases like this, you have to look at the whole picture. You just can't look at a snapshot in time and just accept what one party says over the other party. You look at the whole thing. And this court has always believed in rehabilitation. The reason is, at the end of the day, again, the individual, let's be honest, the cost to the state in housing individuals like this, the burden upon law enforcement, the burden upon the community, the threat to the community, all this plays into account when a court has to fashion an appropriate sentence. And Mr. Glaze, on behalf of Mr. Slabaugh, has done an excellent job in getting Mr. Slabaugh in the right direction. He made a terrible, terrible mistake. But as a result of that mistake, there was some learning behind it, and he was given an opportunity. And that's what Holmes Youthful Trainee Status is all about. The idea of Holmes Youthful Trainee Status is to take young offenders who make dumb mistakes, no disrespect, dumb mistakes, learn from them, be productive, and move on. And as Mr. Rutkowski stated, this court does it a lot for youthful offenders, first-time drug offenders as well. And the reason behind it is, you know, we can just throw them in jail or prison, throw away the key, but what's it helping? When that person is released from a jail or released from a prison facility, is there anything that helped them so that they don't reoffend? In this case, the probation violations are unrelated to the initial charge and plea that was entered in this case. And from the court's perspective, above anything else, this court does not like the idea of yanking someone's HYTA or 7411 status, whatever it is, even diversion on domestic violence cases. It's not happened just once, but it happened twice here. And both violations involve substance use. And on one hand, because it's unrelated, there's a possibility, well, maybe because it's unrelated, we should continue this. But here's the problem with that. What does this court tell other people who get HYTA status or 7411 status and they toe the line and they work their tails off and they sit back, learn from it, I'm not doing that again? Now, in cases like this, if it had been merely consuming alcohol, that's one thing. But consuming and driving, that's a violation of the law. And the court cannot turn a blind eye to that, sadly. And the court, frankly, in this case and other cases, is disappointed. I'm disappointed. Personally, I'm disappointed because I don't want a youthful offender who's made a dumb mistake, no disrespect again, to face incarceration, lifelong stigma based upon the conviction, and a conviction, frankly, that is the scarlet letter, so to speak, upon an individual when they try to turn things around, be productive. But what's a court to do when you're given all these chances? And it's disappointing. It saddens me. It's sad to me personally because I could be on that side. I could be on the other side of the podium. And frankly speaking, probably after the first time for me, I would probably be in a different state as well. But it's Fisher cut bait. And at this point, the court has extended as far as the court can extend. It will be the sentence of this court that the HYTA status is revoked. Sadly. Criminal sexual conduct, third-degree conviction enters. Unsuccessful discharge from probation. He's to register in the Michigan Sex Offender Registry Act, comply with all requirements of the Act, and all the rules pertaining to it. And here's the difficult one. Defendant is committed to the Michigan Corrections Commission, placed in their custody for a period of 15 months to a maximum of 15 years, credit for 85 days previously served. Second, my duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, the court will assign counsel for him at public expense. He's conditioned to receive a questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Mr. Slabaugh, I'm sorry, but the court has to do what the court has to do to be fair to everyone. And at the end of this, after you serve your time, I hope that you learned from this, and I don't want to see you in this building again. No disrespect again. I wish you the best.
Yeah, just a quick question.
Go ahead.
Does the court, one of my requests that were, if incarceration were to be a sentence, that you would sentence them to Funk Correctional with other private inmates, does that have to be placed on the record? Is that something the court considers? Or is that something that is a matter of course?
I think it's a matter of course. And I think that would be part of the oath.
Okay. And does he go into custody today, or would you like to report?
Today. Reports immediately. Remand in the custody of the sheriff. Thank you.
15 months to 15 years. That's quite a swing there. Good luck with that. Good morning once again, everybody. TCF Live on a Monday where we celebrate Gigi being a channel member for 6 months now. Gigi, it is not the same when we have a morning without you, so thank you for being a part of the community. Let's go to Florida, Judge Mercer.
Ms. Harden, good morning. Ms. Harden, you're here because you've been accused of violating the terms of your county probation, ma'am. I'm appointing the public defender's officer to represent you. Ms. Harden, please listen to Mr. McDaniel, your attorney.
I spoke to Ms. Harden at this point in time. She's going to admit she violated probation. Understand 30 days in county jail, 3 days jail credit, remain fine on the case, and that resolved this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Harden, did you hear that agreement?
Yes, I heard it, but isn't it 4 days? Because I came Friday, Saturday, Sunday, and the day is Monday.
Well, you get credit. You'll get credit for today once the jail puts it in the system, but you get credit for Friday. You get credit for everything before today, and then you will get credit for today, but not until they put it in the system. What happens if we give you credit for 4 days, the system will give you another credit for that day. So you actually get 2 days credit if we do it the other way. We learned that a while back. So, Ms. Harden, any other questions?
Yes, I'm on disability, sir. So is there any way you can waive this from court costs and fines or whatever the case may be? Because I can't afford it, and I don't want to come back to jail for nothing.
You'll get a chance to work it off, number one, at the jail. Number two, you can't come back to jail for it. If you don't pay it, they can suspend your driver's license, and they can issue a civil judgment against you, but we don't incarcerate people for not paying court costs and fines. Now, if you get caught driving with a license suspended, that's a different question. But you'll get a chance to work it off, and if you have physical limitations, the jail still can't disqualify you from the work release or the trustee program for that. So if you're willing to try to do something at the jail, they'll find something you can do, okay?
Yeah, I'm going to do something. Yes, sir.
Is that the plea you would like to enter, ma'am?
Yeah, I don't have no other choice.
Remaining court costs and fines, 240. Ms. Harden, I'm going to accept your admission that you violated the terms of your probation, ma'am. I'm going to revoke that probation, sentence you to 30 days in the county jail, credit for 3 days. 3 days you've already served, court costs and fines you have left to $240. Ms. Harden, there's no probation involved in this sentence. So, ma'am, when you finish this sentence, you're through with this case. And as I mentioned, you certainly may or may not qualify for some extra gain time under Florida's gain time law. I've encouraged you to talk to the jail about the trustee program, okay?
I will.
Wish you the best, ma'am.
Thank you.
Yes, ma'am. Angela Moore. Ms. Moore, good morning. Ms. Moore, you're here accused of one count of trespass after warning, ma'am. There is probable cause in the complaint. I'm appointing the public defender's office to represent you. Listen to Mr. McDaniel, please.
Your Honor, I spoke to Ms. Moore. She's going to plead no contest in charge of trespassing. The understanding should be sentenced to 4 months in the county jail, 3 days jail credit, $370 fine. She's waived her right to a trial and call witnesses, and this resolved this case today.
Thank you, Mr. Mitchell.
That is agreeable with the state, Your Honor.
Thank you. Ms. Moore, did you hear that agreement, ma'am?
Yes, sir.
Ms. Moore, do you have any questions about that agreement?
No, sir.
And is that the plea you would like to enter to resolve this case, ma'am?
Yes, sir.
I'm going to accept your plea of no contest to the charge of trespass after warning and first-degree misdemeanor. I'm going to judge you guilty of that offense and issue you to 4 months in jail. But Ms. Moore, you have credit for 3 days you've already served, and I'm going to impose court costs and fines of $370, ma'am. No probation involved in this sentence. You finish the jail sentence, you're through with the case. Ms. Moore, do you have any questions?
No, sir. Thank you, Mr. Moore.
Wish you the best, Ms. Moore. Sorry, Don. Just that too far. Mr. Bellamy, good morning. Mr. McDaniel, Ms. Williams explained to me the issue with Mr. Bellamy and why I couldn't find that one case. There is a separate trespassing in the EWART system.
He was arrested Friday for the warrant and for the a new charge, I guess. They at a different location. I've seen it. So he's got 2 charges of trespassing, and we're going to take care of them.
Perfect. So, Mr. Bellamy, you have 2 different trespassings occurring within a few days of each other, allegedly. I'm appointing the public defender's office to represent you. There is a probable cause for those charges. Please listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Bellamy and the new charge of trespassing and the warrant charge in case number 26313MM. He's going to plead no contest to the charges as listed. The understanding he'll be sentenced to 4 months in the county jail, 3 days jail credit, $370 fine for each case. He has signed his plea waiver form, waiving his right to jury trial and call witnesses, and this will resolve these cases today. Yes.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Bellamy, did you hear that agreement?
Yes, sir.
And do you have any questions about that agreement?
No, sir.
Mr. Bellamy, is that the plea you would like to enter to resolve these 2 cases?
Yes, sir.
All right, I'm going to accept your plea of no contest to these two cases of trespass, first-degree misdemeanor. I'm going to adjudicate you guilty of these offenses. Mr. Bellamy, sentence you to 4 months in jail on each case concurrently. So it's running at one time. It's one sentence. 3 days credit on both sentences, $370 court costs and fines in both cases. And just like I told Ms. Moore, you certainly may do less than that with Florida's game time law. I would encourage you to talk to the jail about their trustee program. Mr. Bellamy, any questions?
No, sir.
Wish you the best, Mr. Bellamy.
I thank you. You have a great evening.
You too, sir. Carlos Jones.
Hey, Judge, good morning.
Mr. Jones, good morning. I see you in the bank one day and see it first appearance a few days later. That's the way it goes sometimes.
Yes, sir. Nice to see you, Judge. Hope we get this
Mr. Jones, we're just going to get you a lawyer appointed today. It looks like you're accused of violating your probation, and there is a signed warrant signed by the circuit judge with no bond. So what I want to do is arraign you today and get your lawyer appointed if you're wanting one. Mr. Jones, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel, and we'll see if you have any questions in just a minute.
Your Honor, I spoke to Mr. Jones. We're going to plead not guilty. I set this in July 9th pretrial docket, and I advise him that the attorney from the PD's office will come by and talk to you prior to that hearing.
July 9th. Mr. Mitchell, anything?
Nothing, Your Honor.
Mr. Jones, any questions about that, sir?
Just Mr. Probation.
I wish you the best. They'll come see you before your court date, Mr. Jones, okay?
Thank you, Judge.
Yes, sir. Have a good day. Ernest Dixon. Mr. Dixon, good morning. You were first appeared this weekend for a charge of trespass after warning and resisting an officer without violence. The weekend judge, the judge covering, set you a bond. We brought you back up today to try to resolve it. Listen to Mr. McDaniel, and we'll see where we stand in your case, sir.
Your Honor, I spoke to Mr. Dixon. At this point in time, we're going to plead no contest to the charges as listed. Understanding since 9 months in county jail, 2 days jail credit, $370 fine. He has waived his right to a jury trial and call witnesses, and this resolved this case today.
Thank you. Mr. Mitchell's at agreeable with the state.
It is, Your Honor. Did 2 days credit?
That's what he said, yes. Mr. Dixon, did you hear that agreement?
Yes, sir. But can I tell you something?
Sure.
I wasn't trespassed from the Manors. I was trespassed for one apartment in the Manors. What we do about that?
It depends on what the trespass warning says and what they says what their version of it is. Now they're saying you were trespassed from the complex. That's what their version is. You do not have to take this plea offer today. If you don't want to take the plea offer, then Mr. McDaniel work on the case. He'll have the right to get all the paperwork and interview everybody and go from there. The offer may change, it may not. I simply don't know. So, Mr. Dixon, if you want to resolve it today, you can, but you don't have to. The judge has already set you a bond. If you want to try to post a bond, that's fine too, and we'll give you another court date.
But they said I'm trespassed from the entire Manor?
That's what the complaint says.
Y'all ain't seen the document of trespass?
No, I haven't seen a written trespass warning. I don't know if there is a written trespass warning. I simply don't know. Sometimes they just tell you verbally and then they put it in their system. The officer goes and puts it in their system. Yeah, let's see what the complaint says. Well, the complaint says that Ernest has a trespass warning on the property, and then where it says the property, it says the Graceland Manors. So, Mr. Dixon, if you want to look into it more, Mr. McDaniel's glad to do that. That's his job. But right now, this is the offer today. It may change. It may not. I simply don't know.
They said trespass only property. It's like an apartment, right?
No, they don't say that. They don't say they don't take that. They normally would say trespass from apartment number 9 or number 12 or whatever. It doesn't say that. This says you were trespassed from that complex. Now, again, you don't have to take this plea offer, but if you want to, you can. Would you rather wait?
Yeah, y'all gonna check on that for me?
Mr. McDaniel will be glad to look into it. Yeah. Yep. Sure.
Yeah, it was one apartment.
I'm going to ask Mr. Mitchell also, would you notify the officer and tell him that Mr. Dixon almost always enters a plea of no contest at first appearance. And he just got out, and then the next day he was arrested for this. So ask the officer to double check, and then that'll be something you can provide to Mr. McDaniel. You got the bond that was set for you. As far as scheduling, Mr. McDaniel, what's your preference?
Your Honor, I mean, I've dealt with Mr. It's like you said, he normally, I'd already put him down as a plea. He always pleads no contest. And I was kind of surprised this morning when he told me that. So I would ask the court maybe to go ahead and let's put him on that jail arraignment docket that's coming up. He ain't going to post a bond. He can't post a bond. And then I'll go ahead, if the court arraigns me, I'll go ahead and send out a request to the police department for those items, or actually the jail.
Mr. Mr. Mitchell, I think I interrupted you. What were you about to say?
No, that was all good.
Do you have any problem going ahead and arraigning Mr. Dixon?
No, no problem.
Mr. Dixon, I'm going to appoint the public defender's officer to represent you. That'll give Mr. McDaniel some starting point to go ahead and start doing some work on the case. As far as the next court date, July the 8th will be your court date. Now, if you post bond, that court date may change, and you get to use the phone to try. If you don't post bond, then we'll see you July 8th. Any questions, Mr. Dixon?
No, sir.
All right. Have a good day, sir. I believe that's it for first appearances, and we have Mr. Bruton, Adam Bruton. Mr. Bruton, good morning. Mr. Bruton, you're being brought back today. I think the plan is to try to enter a plea in your pending felony case. We've got probation here. I think Mr. McDaniel's here on behalf of your attorney, Ms. Simpson. Mr. Mitchell's here on behalf of the state. Your girlfriend is also present in the courtroom. Mr. Bruton, listen to Mr. McDaniel and see if we where we go with this case.
Your Honor, I'm standing in for Ms. Simpson, who has already spoken to Mr. Bruton. He has signed a plea waiver form, waiving his right to a trial and consenting to the sentence that I'm about to put on the record. He's going to be pleading no contest to child abuse. The adjudication of that would be withheld. 18 months of probation, concurrent with any other charges that may exist. Court fines and costs as instructed by the clerk of court. $100 hours of public service work, be $20 a month in supervision costs. He'll do a drug and alcohol evaluation and counseling as recommended by state probation. That has to be done within 30 days, I believe. No, it just has to be done, not within 30 days. And we do stipulate to the facts of the case and whatever costs for prosecution, we agree with that, Your Honor. No contact with Mary Culpepper. He has taken anger management class. And we're asking the court to recommend a transfer to Miami-Dade County where he lives at.
All right, thank you, Mr. McDaniel. Mr. Mitchell, is that all agreeable with the state?
It is all agreeable with the state. I've run it by ASA, Gill, and he says this is the agreement.
All right, so Mr. Bruton, let me get you to raise your right hand, please. Mr. Bruton, do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Bruton, did you hear everything that Mr. McDaniel just put on the record?
Yes, sir.
I have been provided a 2-page plea waiver and consent form. It appears to have Ms. Simpson's signature on it and your signature. Did you go over that form with your attorney?
Yeah, last week, Tuesday.
Mr. Bruton, have you been promised anything to get you to enter this plea other than what's on the plea form and what he just put on the record?
No.
You feel like this plea is in your best interest?
Yes.
Mr. Bruton, you understand you've got the right to go to a trial and have a jury of your peers hear this case. You'll be represented by an attorney at that trial. But if you enter this plea, there will not be a trial, Mr. Bruton. You understand you're waiving your right to a trial?
Yes.
Do you also understand that by entering this plea, you're waiving your right to call and cross-examine witnesses on your own behalf?
Yes.
And is this what you want to do, Mr. Bruton?
Yes.
Mr. Bruton, Mr. McDaniel, anything else before I accept the plea?
Maybe ask him if he's satisfied with Ms. Simpson's work in the case.
That is a standard. Thank you. That's a standard question I'm supposed to ask. Mr. Bruton, are you satisfied with the services of your attorney?
Yeah, I was. Appreciate it.
Okay.
Thank you.
Mr. Bruton, I'm going to accept your plea of no contest to the charge of child abuse. Adjudication of guilt will be withheld. The case number is 25-411CF. I'm going to place you on probation for a period of 18 months. It says concurrent, but it's just one count. So it's nothing to be concurrent with as far as I can tell. Mr. Mitchell?
Yeah, that's what I'm seeing.
It's just
also, I may have missed it, but you said no contact with Mary Culpepper. There is also a condition of no contact with the alleged victim, the child.
Okay, I haven't got to that yet, so I'll that's on the plea form. Thank you. 18 months probation, court costs and fines amount of $1,251. Mr. McDaniels waived the reading of those costs and fines. 100 hours of public service work will be imposed. $20 a month costly provision, drug and alcohol evaluation and counseling. Is there a time limit with state probation on when he does that typically, Madam Probation Officer?
Within 30 days.
Okay, so the referral will take place within 30 days. Defendant stipulates to the factual basis. Mr. McDaniels already put that on the record. Defendant agrees to imposition of minimum cost of prosecution. That's included in the 1251 though, right? That's included in the 1251. It says forfeit any seized items. Were there any seized items in this case, Mr. Mitchell?
Not that I'm aware of.
Yeah, I'm not sure of this form.
Standardly, usually just checked. And
Why would they check if there's no seized items? Jeannie don't fill it out. The attorneys fill this out. No contact with CC, which is a juvenile, presumably.
Yes.
And no contact with Mary Culpepper, an adult. Anger management is written down here. Just says anger management. Is that anger management is part of the plea agreement?
Yes.
And that was part of what Mr. McDaniel announced?
Yes. Oh, he may not have said it.
Is anger management part of the plea agreement, Mr. McDaniel? Okay. Thank you, Madam Clerk has answered it. And lastly, you'll be allowed to transfer this case to Miami-Dade County as that is where you reside at. Mr. Bruton, I think that's everything. You do have the right to appeal an illegal sentence. I don't think I've imposed an illegal sentence because this is a third-degree felony, so it carries a maximum of 5 years in prison. So it's not an illegal sentence. But if you think it is, you've got to file a notice of appeal within 30 days if you want to appeal that. So, Madam Probation Officer, correct me if I'm wrong. He'll be released this morning as long as he has no holds anywhere. And upon being released, he needs to report immediately to the Jackson County Probation Office. Correct? Any other instructions I need to give him from y'all? I'm talking to your girlfriend now, ma'am. Do you have any questions? Any other questions? So when you get him at the jail, are you gonna pick him up? Your girlfriend's gonna pick you up. She's gonna, once you're released, she's gonna take you to probation so you can check in there and get everything straight, Mr. Bruton, then you'll be free to leave. Mr. Mitchell, anything else from the state?
Yes, on top of the illegal sentence that you were talking about in that situation, this is a guideline. It is guidelines what this plea offer is.
Thank you. Thank you for putting that on record. Mr. McDaniel, anything else on behalf of Mr. Bruton?
No, Your Honor.
Mr. Bruton, any questions?
No, sir.
Mr. Bruton, I wish you the best, sir.
Thank you.
And I don't, probably just for record purposes, there'll be no further action taken on the contempt of court. He was held in jail over the weekend for the, not contempt of court, for the violation of conditional release order to show cause. Wish you the best, Mr. Bruton. Date this form. Today's the 22nd. Second. That's yours. That's trash. Mr. McDaniel, that's everything I had on my list unless I missed something, which is certainly possible. Anything else, Mr. McDaniel, on behalf of the Public Defender's Office?
No, Your Honor.
Sorry.
Alrighty, friends, that does it for Judge Mercer this morning. Let's go back up to Michigan. We'll check in with Judge McNally.
I will bring on behalf of Jessica Naya, who's up there for the reporting. She's done my lab. Please identify herself.
So I initially placed the defendant on probation on May 15 of 25, took her plea under 771.1. That was revoked when she didn't do anything. I then sentenced her to 20 hours of community service by June 1. That was March the 19th. How is she going to proceed?
Judge, we plead guilty, but of course there's an explanation.
If you plead guilty here, ma'am, I want you to understand you could get 10 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights form?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
To the charge, failure to provide proof of completing 20 hours of community service by June 1st, how do you plead? Sorry.
Guilty.
Did you fail to provide proof of completing 20 hours of community service by that day?
I did.
Anybody force you to plead guilty?
No, sir.
Plea is accepted to that charge. Your name, please.
Inspiration.
What is going on here?
Judge, it's a lack of transportation. She was sharing a vehicle with her partner. The engine blew, and
When did that happen?
it happened within the last month and a half.
When?
The last month.
The last month?
It happened like May
20-something.
Well, you had to have it done by June 1, so you hadn't done anything up until the engine blew on May the 20-something?
No, all I did before that was the 8 hours of community service and the 2 court work days.
You were supposed to do 20 hours of community service. Enlighten me here.
So we're here today in 2 separate cases. The one, she did not complete any of her 20 hours. On the other case,
What other case? I'm sorry, I don't have it.
there's, the furnishing alcohol to.
You have that one. I thought I had another one for Jessica and I.
There was 2, I have.
That was the one I gave you to give to Mr. Graziani, I think.
That's the one that he just gave you back.
How many did you talk
There's
to her?
nothing.
How many did you talk to her about?
Judge, I just spoke to her about one matter.
Which one?
It was regarding the furnishing of alcohol to a minor and also the disorderly conduct.
So the disorderly conduct, yes, it's a separate case. That's the one that you had adjourned from May 21st.
Hang on a second. I think it must be in, I don't know where it is. I gotta find that one. I'll go look in. You can check. Oh, here it is. My day, jeez. Now I also have Jessica Lynn and I at 254-240. All right, so everybody's name again on this one. Sorry.
John Graziani, appearing on behalf of Jessica and I.
Your name? So on this one, she pled guilty to failure to attend her probation visit on May the 11th. Failed to pay fines and costs as ordered. And failed to clear all warrants by May 1 of 26.
Judge, again, she didn't express herself well. The car, the truck, the junk truck had been having a lot of problems. It's been back and forth with me. Engine didn't blow, and this person honestly wants to complete it. It's just.
I don't know why. She just got done telling me, unless I misheard, that the car didn't blow up until May 20th.
That's correct, Judge.
What did that have to do with her not clearing her warrants by May the 1? What did that have to do with her not paying her fines? And what did that have to do with her not reporting to probation?
Judge, what happened is she simply doesn't have transportation, is unable to make any kind of money. She was about $500 a month on a bridge card for herself. And
does she work?
She is working she's on a list at Culver's in April. In fact, they were kind enough to keep her on the list until the transportation issue was resolved. She and her partner worked separate shifts so as to be in a position to make ends meet and ultimately take care of this matter, Judge. Judge, I know it's frustrating, but she's in a bad position. She really is financially.
Whoa. Who wouldn't be if you didn't work? Why aren't you working? Do you have children?
I do.
How old?
I have a 1-year-old and a 13, 14-year-old.
The 13 and 14 is normally in the custody of her ex. And what's happened, Judge, is because of her financial situation, she's really unable to take care of the 13 and 14-year-olds, which is just led her to them. You know,
You have somebody who watches the 1-year-old when you're working.
Usually my mother.
Well, why don't you get your mother to watch her every day so you can go out and work and you won't have to be living on $500 a month? Who can do that?
It's hard.
I know it might be hard, but you got yourself into some trouble here and you haven't complied at all.
Judge, to her credit, she did put in 8 hours of community service. She did 2 days of corporal program and although she was late.
What did she do that on?
So that was right after she got sentenced, which was. End of April, end of May. Have it in mind. I can use my computer if you want.
What I mean, I don't know what to do with her anymore at this point, to be honest with you. I'm not gonna just let this go.
Judge, I would ask that, even though it's been frustrating for everyone, particularly herself, and for Ms. Raftis, she needs to complete this probation. She wants to do it, and she has to face the consequences.
You could have fooled me. How,
Judge, this is an example of truly living on the edge.
I don't want to sound harsh, but we put ourselves in these positions. And kids are wonderful. With them come responsibilities. And I'm just surprised you didn't take advantage of my kind gesture to let you do the community service on the other case. I've already revoked that status. You didn't go and clear any of your warrants. Maybe you don't have the money. I don't know what to tell you. If you walk in there and you talk to the judge like an adult and say, I'm sorry, and you schedule my case, you might find that they're more receptive than you can imagine.
Chuck, again, I know it's a broken record, but it is transportation along with not being able to brought two nickels to get out of the cycle. I guarantee if this is continued, she'll make an effort, even if it's like $30 or $40 a month. I mean, it's very small, but she'll make that effort, Judge. If you did do the community service, for her to complete it, the 2 days of the court program is not only particularly in her situation.
Really funny. She did complete those right after she was sentenced. However, she has taken a trip to Miami since then. But we've received no payments.
What was the trip to Miami for?
It was my sister's birthdays. Two of my sisters had a birthday done.
And I'm glad you got to go to your sister's birthday, but sometimes there's priorities.
But I wasn't aware of that.
It was a paid for trip. I didn't pay.
I don't have a problem with you going. I have a problem with you not fulfilling your obligations.
I understand.
I also, this isn't part of the violation, but I also just received a notice from Class A, compliance notice because she failed to complete her program. Her Class A as well.
Is that the program where she has to pay $135?
Yes,
Again,
but it's online. You don't have to transportation with you. There is a cost to it.
again, Judge, it's a matter of.
How are you going to fix the problem? You are an adult. How old are you?
36.
So you're an adult, you're 36 years old. How are you going to fix the problem?
I'm sure with the transportation being fixed now that I'll be able to get to my community service. Also, they put me back on the schedule.
How are you going to fix your financial problem?
Start working a better job. I'm looking, it's hard.
Judge, she is.
Well, I got the impression you were getting $500 a month in bridge card benefits and little or nothing else from working at Culver's off and on. How are you going to fix your financial problem? What are you going to do? Can your mother watch the child more?
Yeah.
Get to work.
Trust me, I want to.
Ma'am, I understand it's not easy to raise children, especially infants like that. I get it. But you got to think about how you're going to fix your problems. You can't just throw up your arms and say, hey, I had car problems. I mean, I don't want to sound harsh about this, but we put ourselves in position. That's what we do in this crazy world. Sometimes we make good decisions. Sometimes we make bad decisions. When we make bad decisions, we have to live with them. And then we have to figure out a way to dig ourselves out of the hole. It doesn't sound to me like you're doing it. I'm just telling you.
Judge, again, I'm asking for a continuation of probation. I know it's
Well,
frustrating for the department and your son.
I'm not worried about frustration for me. I'm worried about her acting like an adult. No disrespect intended. I really am. Another sentencing date, please, Stephanie. If you can go out about a month on this, that would be good.
Okay, Judge, we are looking at, let's see.
Take your time. I don't know. And I'm gonna adjourn the sentencing on the,
We're looking at
Judge.
July 20th.
that's fine. I'll set a sentencing date on July the 20th on both of these at 8:30. Now, I expect that you will have your 20 hours community service done. I expect that you will clear all of your warrants on the disorder. I have not revoked that 771 status as of yet.
Thank you, Judge.
And I will, you missed your payment. I'm gonna expect you to get on track, but you gotta work. You understand what I'm saying? You'll feel good about yourself. You know, we can't survive on $500 and a couple odd days working at Culver's every month. I mean, I don't know how anybody can eat. So I'm gonna wish you well. I'm gonna be fair with you, but you gotta show me more of an effort. And I'm gonna trust you're gonna come back here with some kind of opinion. My mother's gonna watch my child on these days. I have applied for jobs at these locations. Good luck. You can go down the hall and get your new notices. Thank you very much. Aaron.
Hour 2 of TCF Live on this fine Monday. Good to have you all here. So, new people who might be around, you might not be aware, we have a game that you can play here while you're watching court with us. It's a bingo game. You can find it at tcfbingo.com. If you go there, click on super cool mode, you'll actually get your bingo card, the court feed, and the chat all on one screen. And basically, you fill out a bingo card based on what you see in the court. It's a lot of fun. Give it a go.
All right, 170 is your total. You can go down the hall and pay that and you're all set. Best of luck. People against Jeffrey Krapko. 26 T648694. Your name, sir?
Good morning, Your Honor. Jeffrey Krapko, appearing pro se for the purpose of these proceedings.
Appearing in pro se?
Yeah, Your Honor.
Are you a lawyer?
I am.
Have you been in front of me before?
A while ago, yes.
Then you know better than to do this. You know, it's funny. I was coming back from up north yesterday. And some young lady in her 20s has she's driving in the left lane. She's got the whole I-75 southbound, southbound backed up. She's going 65 miles an hour in the left lane, and I'm going by her, and she is in la la land with seriously, with the phone up to her ear.
All I can say, Your Honor, is that's not what happened here, but.
Tell me what happened. You're gonna plead to impeding, right?
That's right, sir.
To that charge, responsible or not responsible?
Responsible.
I'm not gonna lecture you, but you know what I'm saying. Why were you using a handheld device?
Pulling it up to grab a contact, to send an audio message to my parents about my son's award he got at school. I don't want to fight it. I see that there's an exemption in the statute, but I just want to get this over with and resolve. So that's why.
Well, I hope I have the pleasure of having you practice. What kind of work do you do?
I'm a federal prosecutor now, sir.
Oh, wow. Federal prosecutor. Good
Yes.
for you. I mean, that's impressive.
And last time I was in front of you, I was a defense attorney, not having a client on probation, so.
Did you win? Did I treat you good?
You did treat me well, and I did win. So.
$200. Sorry. Have a good day. That's my standard fine. Have a great day. Good luck.
Barbara, thank you for the $10 super chat. And Gigi, thank you for the $2. Appreciate you both.
26 T648580. That's a true story, by the way. Yes, it
is.
I mean, just like in La La Land, like I just, it was unbelievable. She's got 30 cars backed up because she's on the phone driving 65 in the left lane. Your name?
From here.
Did they offer you anything, or you just want to you want to have a trial here? You want to go to a hearing?
Really wanted hearing, Your Honor, but they said that there's nothing they can do besides paying it, and I thought like there wasn't any common courtesy taken.
Multiple complaints called in on vehicle parked left wheel to curb
it was right in front of my home
Yeah,
and,
but you can't park the wrong way. That's what they're saying, right?
right, my daughter didn't realize she wasn't all the way on the lawn. She did that,
Who parked the car there?
my daughter. And we've lived there for 5 years when I was home.
Yeah, but she can't do that. She knows that, right?
No, we didn't know that, and we haven't done it since, Your Honor. And like the neighbor that complains about us dislikes us.
Well, I know, but you can't do that though. You know that.
She's still.
How old is she?
The road. She just turned 19.
She's had her license for 3 years.
Yeah.
She should know better, right?
At our home.
Here's what I'll do.
Oh.
Okay, if you want to have an informal hearing, I'll give you an informal hearing. You're gonna lose. You're gonna lose based on what you just told me. Okay? I can't start making up my own rules here. If you want to plead responsible and you promise me you're not gonna do that anymore and your daughter's not gonna do that anymore, I'll charge you $55. It's up to you.
Okay, Your Honor.
You want to do that? But you're not gonna do that, right?
Correct. We have not since we.
Good. To the charge prohibited parking, responsible or not responsible.
Responsible.
All right. I'll accept the plea. $55, you're all set.
Thank you.
Have a good day. Good luck. Thank you. Do I have Marshawn Andre Moody here? 25B14809-2C. Any reason to believe he's here, John? He was scheduled for 8:45. I'm issuing a warrant.
He did not care. He would be in.
Defendant failed to appear for show cause. He was scheduled for 8:45. It's now 9:18. Bench warrant to issue, bond to be forfeited. 3,000, 10%. 3,000, 10%. People against Zachary Klein. 26T648448. Your name?
Zachary.
All right, so you're gonna plead to impeding traffic, true?
True.
Responsible or not responsible to that? I'll accept the plea. You got one prior, 160 is your total, okay? Cash your end of the hall to your right.
Thank you.
Good luck to you.
Have a good day.
Do I have Kenny here? Do I have, Bryant Allen Kenny the third here? Okay, that one is not up yet. How about Coyne? Emilio Coyne? Emilio Alexander Coyne. I have 23R723037. And I have two files, two counts. I have a possession of an analog, attempt possession of an analog, which is a 1 year. And I have operating while impaired, and the charges are failure to pay fines and costs. And defendant failed to appear. So what I will do is defendant failed to appear for show causes. I have two different files. Counts, I should say. Bench warrant to issue. 5,000, 10% will be the new bond. Bond amount will be 5,000, 10%. So Emilio Coyne failed to appear, and that will be the issue there. Jackson Peter Klug. 269534. You know what? Your name, sir, hang on a second here. I'm gonna need you here. Your name? Your name?
Jackson Toyle.
Your name?
Ahmad.
If there's disabling damage or it's towed. I can't.
You might do the 1 at 5?
I have.
Okay.
Otherwise.
I told him that might be a possibility, sir.
Yeah, because So can you change that on?
Absolutely.
Do you want to plead the 1 to 5 over? It's 1 point. I won't take impeding when you total the car, or at least it's damaged to the extent that it has to be towed.
Yes,
You want to plead the 1 to 5? That is 1 point.
yes.
All right. To the charge 1 to 5 miles per hour over the speed limit, how do you plead, responsible or not responsible?
Responsible.
I'm gonna accept the plea, dismiss the failure to stop, assure to clear distance. 195 is your total. You can go down the end of the hall and make your payment. Okay, good luck. Thank you. Thanks, Lieutenant. Sergeant.
Don't promote me, sir.
Sergeant.
Oh, my God.
All right, Anthony Smith. Just kidding. Anthony Glenn Bramirski, 260-150449. Your name?
Anthony Glenn Street, Your Honor.
Boy, you gotta be careful.
I take full responsibility. I couldn't
I
say.
know, but your record here,
Yeah, I drive for a living. It's,
what do you do for a living?
I fix, kidney dialysis machines.
You gotta be careful.
Yes, sir.
To the charge 1 to 5 over, responsible or not responsible?
Responsible.
There was an accident here, so I gotta charge you more. It's 195. You're all set, and I'll dismiss the failure to signal and observe.
Yes, Your Honor.
Please be careful, okay?
Yes, Your Honor.
195, cast your into the hall to your right. Good luck.
Thank you, Your Honor.
Do I have here anybody with a probation violation? Anybody with a probation violation? Do I have, I'm gonna repeat these names here. Brian Kenny,
He just walked in. Yes, sir.
are you ready? Did you read the advice of rights?
He just gave it.
Bryant Allen Kenny III, 25B148464. Come on up to the podium and tell me your name.
Kenny the third.
I sentenced you February 25 of 26. I have a charge here that alleges you failed to pay all your fines and costs, count 1, count 2, that you failed to clear all of your outstanding warrants by March the 15th of 26. You understand those charges?
Yes.
If you plead guilty, or if you're found guilty, you could have, that'd be 2 technical violations. You could get 10 days. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form?
Yes.
If you plead guilty, you will be giving up all those rights on the advice of rights, and we're not going to have a hearing of any kind. You understand that?
Yes.
You do have the right to an attorney. I'll be happy to provide you with one at public expense if you would like them. Would you like an attorney to represent you?
Yes, please.
I'm going to enter a not guilty plea for you. I'm going to give you a lawyer. And you will meet with your lawyer. And then either way, you're coming back in front of me after you speak to your attorney. Any questions?
No, sir.
So whoever at probation, you can go right out in the hallway and we'll set you up. Good luck. Do I have Wilson Tallison here? Do I have Young here, Alyssa Young here? Do I have Ligber? What? Jesse Andrew Ligeber here? Do I have Marcia Andre Moody? All right. Eric Willis, 26W843164. Okay. You can come on up here and tell me your name if you would, please.
Yeah, my name's Eric Willis.
You're going to plead to impeding, right?
Yes.
To that charge, responsible or not responsible? Plea is accepted. Speed's dismissed. 150 is your total. You got a great record. Good luck. Have a good day. John Joseph Hackinson, 26T648484. How you doing, Mr. Hackinson?
Good, how are you?
Your name?
John Joseph Atkinson.
You're going to plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Plea is accepted. 150 is your total. Cash you into the hall to your right.
Thank you.
Good luck. Mylan Crane. Mylan John Crane. 262-648-660. How you doing?
Howard, can you work by yourself?
Not too bad. Your name?
Mile John Crane.
You're going to plead to impeding traffic, right?
That is correct.
To that charge, responsible or not responsible?
Responsible.
Speeds dismissed. 160 is your total. Cash you into the hall to your right. Thank
Appreciate
you.
it.
Good luck.
Good.
Do I have anybody here on a probation violation at all? If so, raise your right hand. Elena Salos, 26T648375. How you doing, Ms. Sowers?
I'm good, how are you?
Your name?
Alita Swords.
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible for the plea is accepted, no injuries, 195. You're all set. Cash you into the hall to your right. Thank you. Dylan Straughter? Who's on this one? Brownstown.
Brownstown.
Can, Stephanie, how you doing, Mr. Straughter?
Good.
You brought your lawyer with you. What's your name, sir?
My name's Lawrence Strotter as well.
All right, listen, Sergeant Berners, yeah, you're
Yes, brother.
not on this one. This is Brownstown.
Brownstown.
Can we get Brownstown in here? What's the record like, Mr. Straughter?
Fair.
Huh?
That's good on
How are you? You're driving, you got a couple of issues though, right? December 24, there was a hazardous action, unable to stop, assured clear distance, January 26, speeding too fast for conditions. May of 26, improper passing. I don't know how many of those resulted in convictions or not, but you got to slow down and be careful.
Yes, sir.
I mean, these are not toys. How old are you?
18.
Your name?
Sergeant Mott.
You wrote down officer not notified of informal hearing.
As far as we're aware, he was not notified. We have our scheduling software where we can write notes for informals and stuff, and those notes are not in there. Sergeant Smith took his email. He's the one who handles all of that. He has no emails to Officer White regarding to this incident. So just from our.
So we did send out who do we send the notices on the informals to?
We faxed them to the department.
So they did send this out 9 o'clock. I mean, this June 8th, it looks like Mr. Straughter and would have faxed it, just so you know. So I'm a little concerned about the way you're driving though. Why are you driving like that? What are you gonna do? Are you at this, did you just graduate?
Yeah.
From where?
Renaissance.
Now what are we gonna do for a living?
We'll go to college in Morehouse in Atlanta, Georgia.
You gonna slow down?
Yes.
I'm serious. Come on. Who's paying your insurance on the car? Yeah, I mean, come on, right?
Yes.
All right. I'm gonna give you the benefit of the doubt because I do believe we sent this. And I'll go ahead and dismiss the case. The officer didn't show up. They still have to let us know if they have a conflict. You know what I mean?
I have another one, the exact same situation, sir.
With the same officer?
Different officer. Where I just checked our scheduling software and there's no note that says that he's supposed to be here and he was also on vacation.
Well, okay. All right. I'm gonna dismiss this case. If we made an internal error here, then my apologies. But this was an accident too. What are you doing? I'm serious. You gotta be careful. Were you in the car by yourself?
Yes.
Well, what are you doing?
I was just The person in front of me stopped.
Yeah.
We were waiting for a pedestrian.
Yeah.
I was walking across the driveway. So I just decided if they were stopped, I decided to like drive across, like on the other side and pass them.
You couldn't stop it, right?
I did stop. I was stopped behind them. And then I decided to drive like left of them so I can go onto the.
But you caused an accident, right? Oh, no? No. Maybe I'm misunderstanding. It says improper lane accident. That's what it says on
He
the.
hit the back of my car, sir.
I don't need anything. I just, somebody thinks, you have to take your hat off, Mr. Klein. Somebody thinks you caused the accident. I'm not gonna make an issue of it. No, this Mr. Coin on here. I'm not gonna make an issue, but you gotta be careful.
Yes, sir.
I'm serious. You're going to school, you're gonna spend all that money, you wanna use your head. Good luck. Case dismissed. I mean it. Good luck. Thank you for coming, Mr. Strotter. Very.
Halfway through TCF Live on this Monday. A lot of good court out there this morning. A lot to choose from. Let's go to Texas, though. We'll say good morning to Judge West.
No.
Right first.
It's an initial.
Oh, y'all might not even have.
Here, I've got the information from Ashley, so you'll know if you want. Interesting. No. Very good.
Okay.
And keep it so you know her.
Right, sir, are you Christopher Hunt?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Will your honor.
Mr. Hunt, in cause number 25 DCCR 1766, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. So is it assault family violence?
No, it's just Class A assault, not family violence.
Okay. And that's from September 28th of 2025. And how do you plead to that charge?
Not guilty?
No.
No, guilty?
Did you do it or not?
Yeah, it's okay. So are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation.
Yes.
Do you understand? I'm assuming one of those would also be that you have no contact or communication at all with David LeBlanc. Do you understand? That's obviously in person, but that also means any type of communication. You can't send messages or through social media or anything.
Okay.
That'll be a part of your probation. You understand?
That will?
Yes.
Okay.
What? All right. So, are you a U.S. citizen?
Yes.
So what's the relationship with Mr. LeBlanc?
He was a friend of my mom's.
Okay.
He was staying at my house.
All right. So obviously that's no longer acceptable. You cannot be around him at all, period.
We'll make sure that happens.
Okay. State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Hunt is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and follow all of those rules, at the end of your probation period, the case will actually be dismissed if you're successful. So you won't have the conviction on your record.
Okay.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You would be found guilty of the offense and you could be sent to the Jefferson County Jail for up to 1 year. Do you understand?
Yes, ma'am.
All right, if you'll just have a seat here in the courtroom, probation's sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. Just wait for her to call you up.
We thought you were gonna call the next one.
Oh, I gotta get to that docket. I'll get there in just a second. Y'all made me think I'd already said something.
You did, you don't remember?
I don't remember. That could be a problem. See, Stephen Gray, Mr. Parker. Now I'm there. Good morning. Are you Stephen Gray?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Gray, in cause number 26 DCCR 0294, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from December 27th of 2025. The indictment alleges you were previously convicted of driving while intoxicated June 27th of 2012. And after that was final, you were convicted of driving while intoxicated March 7th of 2014. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
And are those two prior convictions true?
Yes, Your Honor.
Right. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. Y'all mark
$1,000 fine.
Okay.
Sorry, and I didn't put 10 days.
That's a condition that's required. So it looks like the fine would be $1,000. You understand a condition of getting probation is also that you would have to serve 10 days in jail
Yes, Your Honor.
and follow all of the other rules and conditions of probation.
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Gray is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. But what I'm going to do is reset your case for about 30, well, actually, it's to be a little longer than that, so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today. And she's sitting at that desk right over there. All right, we'll see you back at sentencing.
All right, friends, like I said earlier, a lot of good court this morning, so we'll probably hop around a little bit more than usual. But let's go to Fulton County, Georgia. Judge Alex Manning, and somebody is approaching with the family. Looks like we brought the children as a shield this morning.
So you got some backup counsel there.
Got my own too today.
Okay. All right. So go ahead.
Got me first. So defendant does have several curfew violations. From March 14th to June 17th, the defendant has approximately 38 curfew violations. Some days have multiple unauthorized stops. The defendant is tracking at apartment complexes, gas stations, kids' learning centers, parks, car washes, restaurants, street corners, shopping plazas, and residential areas and homes, retail shop, food marts, hotels, and the YMCA. I did speak to the defendant and advised him of his bond conditions and reiterated that every time he is leaving the house for reasons other than what is listed in his bond conditions, that it will result in a violation. The defendant does have several dead batteries within the last 60 days. He has 15 days in March, ranging from 12 hours to 73 hours, 29 days in April, ranging from 14 hours to 102 hours, 17 days in May, ranging from 33 hours to 69 hours, and 13 days so far in June, ranging from 10 to 60 hours. I did speak with the defendant on May the 14th. He said that he did something wrong with his charger. I advised him that this is the first we've heard of this because we've called several times and advised him to place his device on the charger. I advised him to report to one of our officers as soon as possible. As of today, the defendant has not currently sold a new charger. And he was asked last court date if he needed a new charger, if anything was wrong, and he said no. He was fine. I did get a charging report, and I can tell you the defendant's charging habits, detention. He was charging less than 30 minutes per charge, and the defendant's charging less than 2 hours required.
All right, go ahead, Mr. Jenkins.
Yes, states with that report at this time, the state's requesting that the defendant be placed in custody. Given the nature of the charges in this matter, we don't believe he is appropriate for bond in the first place. As a result of such, Judge, I know it says it's due for removal or to be reviewed for such. I think it would be appropriate that once the defendant is detained and released eventually, if that is the case, an ankle monitor can be placed back upon him. But until that time, he needs to go into custody with those violations. That's his position. Thank you.
I'm looking at the last charge. What are his bond conditions? I'm trying to pull it up.
No, for some
First
reason,
and last charge, you see it on the, are those indicted?
Not as of yet, Judge.
None of the charges and.
Or are they
still a PI?
Oh, yeah, that's true. I'm trying to see if there were conditions, you know, about the children.
He was allowed to be around his children and take care of his children as needed, Judge. That was mentioned in his bond hearing, and the judge was aware that he is the primary caretaker of his kids. And a lot of the violations that I did hear were things related to taking care of his children. I believe it was a 24-hour curfew with the exception of work, school, medical, and any child.
All right, so you may want to, if you had to talk to her, because I want to know right now, if you didn't have, with what they said, I would put you in jail. So, but you got kids with you. So, I mean, talk to her, I don't understand why that you're 30 minutes. I know you got kids. The kids go to sleep. The kids take naps. You could probably even get a little power bank and charge it. There's other things you can do, but there's some places I heard on there, car washes, all that. They don't have anything to do with the kids. I know the child care center does, but I don't see where anything else has anything to do with the kids.
I mean, he just came back.
So he's stop.
Getting ready.
Second chance. What's the home address that you have?
3239 Desert Circle, Apartment 7, Atlanta, Georgia, 30344.
And that's where he's been staying?
Yes, ma'am.
Go ahead, counsel.
Yes, Judge.
Good to see you.
Good to see you as well. I did just speak with Mr. Starks. As my understanding that when he did first get out, he was struggling with getting, he shares a car with his significant other, but he is the financial and primary caretaker of the children while his significant other works. So if he does need a ride to go get food or go get things for the kids, he is at the liberty of whoever is driving him. And so unfortunately, while he's not made the best of decisions in being at the liberty of somebody else and not explaining his conditions to that person, that is why he was where he was not necessarily supposed to be.
Is your significant other here?
No, Judge, he's here alone today with the children.
Okay, that has nothing.
Also,
go ahead.
Pregnant. Just they are due for another child, Your Honor. So.
All right, so one, that has nothing to do with charging, and if they called you and said you could go by there, you gotta do that. I'm not taking the ankle monitor off of you. Absolutely not.
And we're not asking for his ankle monitor to be taken off, Judge. I'm just asking for him to get a second chance to show that he can abide by the conditions of his ankle monitor.
Ms. Burns, Ms. Burns, you know the July calendar date? All right, so July will be about the 20th.
I'm on leave on July 20th.
Oh, you are?
Yes.
This is true. You got August? You got August yet or no? You have any leave in August?
No, Judge.
Okay, so whatever our date is in August, we're gonna put you on there. But when you come back this time, leave the children with the significant other. Okay, when you come back in August. Okay?
All the time.
Who you want? Yeah, oh yeah, yeah.
And Judge, that does conclude my.
So, is there anything else that second chance that you need that's?
So we do update contact information from Mr. Starks. The other thing, Your Honor, is on his bond order, it just, like, it doesn't have basic life necessities, and it doesn't have that he's able to take his kids to the kids learning center. I'm assuming is for his kids, or the YMCA. And we just have that there's no contact with any minors, which minors would be present there, other than his biological children. So
what are you doing at the YMCA?
YMCA?
Yeah.
It was probably to drop off a DoorDash or something.
Who was? A little bit loud. You put it.
It was probably when I was catching a ride for somebody that was doing DoorDash while picking me up, and so they probably stopped by YMCA.
So have you told these people that if they don't, that could cause you to get locked up? I mean, I understand your circumstances completely, because we've been down the one car, but the actions they take could get you locked up. You going by the YMCA because there are children there. So they need current contact information, and we're going to put a brand new one on there. I think the piece of paper that you sign says says 2 hours in the morning and 2 hours in the evening. Not 30 minutes. 30 minutes doesn't do anything. So 2 hours in the morning, 2 hours in the evening. Like I said, when you come back in August, do not bring the children with you.
Yes, ma'am.
Okay? That's the only thing that's keeping me from putting you in jail today. Of course, I'm your lawyer, but that's it. So if I were you, I'd have absolutely no violations. And if you have to, and communicate with them, like somebody's giving me a ride and they have to stop by the hospital before they do or something. You got to call and explain to them, okay? Because if you do that, then they can keep up with it and then they'll know. Okay. All right. But I need you to go over there and give her your updated contact information, get a new ankle monitor, and we'll see you in August when we get the date. We'll send you the date.
Okay, sounds good, Judge.
All right.
Hour number 2 of TCF Live. It's good to have you all here with me today. I hope you're enjoying the court. I know I am. Lots of good stuff going on this morning. Good God. Anytime I go to Fulton County, I expect bad audio. That's like a given. But that set a new record. And I hate that because I love Judge Manning. We don't get to see her every day. She doesn't stream that often. But it's especially bad today, so we need to move on. Michael Groff, you seriously need to contract with Fulton County. I figure you can do a 1-year contract, say $120,000, so $10,000 a month, and go fix their audio. Change your life and theirs, just saying. Judge Stevens, Texas.
Arius Wilson?
Yes, sir.
Who's your attorney?
Right.
Yeah, I was court appointed, but I believe she hired, right?
Okay.
Did you? I mean, you know who.
Yeah, I've been court that 2 times already.
Yeah, my God, I can remember.
Yes, sir.
I got 5,000 cases. I got 5,000. Sorry. I'm doing good to remember some of my uncles and aunts. Hey, Rife, on this one, this is your lady, right? Miss Wilson? Langston used to be representative, now you are? Just what do y'all plan to do? Have you talked to him, ma'am? Have you talked to him at all?
Yes.
You have? Okay. He's signing up somebody right now, and then he'll talk to you next, okay? And then we'll call you back.
Okay. Thank you, Judge. Appreciate you.
But you're out of it, right?
No, I'm out of that one. We'll pass. Yeah, I'm positive. What is it?
Okay. Tiana Baker?
Morning, Judge. She's present. Are we present?
Depends what you have to say.
Judge, there is a security video that was mentioned in an offense report that we're trying to
don't have it.
locate, and the defense thinks it might help their case and be exculpatory, and we're trying to find it. And I may have to pull the evidence out of the BPD locker room and look through all the discs that are in there, make sure they didn't put it in there.
It's just
one more reset to another child.
This thing's over a year and a half old.
Yes, sir.
Now we're looking for evidence.
Well, we've been looking for it for a little while, and we went through all the computer and got that all brought over to our office and been looking for it. Now we're looking physically for it to make sure it's not there.
It involves injury to a child.
Yes,
So
sir.
that's always,
It's serious. Yes, sir.
well, it has its degree of most importance under the rules. That gets accelerated to the top. And
Yes, sir. And we just need one more just
to go look for stuff, you know?
I just need to make sure it's not there, Judge. That
Judge, I think what happened was the prosecutor was on this case, I think resigned or moved on with and so I was dealing with her and I think I didn't know she had left. And so I reached out to the chief to address this issue and I know he's on it. It's crucial for us, Judge, because
I can appreciate it. It's just on the clock, like it's a year and a half old when y'all are looking at how long is this going to take?
if we get one more trial setting, Judge, another 4 weeks, so we can get it. We'll know for sure one way or the other.
Sure. Thank you.
Desmond Limbrick. Brett?
Judge, it's gonna be a great.
No.
Hey, Judge, when if you want that one, 2, 3, the third case on the trial. All the papers.
That's correct.
That's the ready for you. I can do that for you right now. That's on the trial docket.
Really? Do you need to go somewhere?
No.
You want to do it first?
I was going to do it.
Well, we're gonna put it right.
Hey, it's on the trial docket. We can move out.
Just trying to feel you out there. I don't know how you are on this. Yeah, we'll get, let me just go through it. I'm almost through and then we'll.
That's cool.
Mr. Limbrick is here. I'm doing paperwork.
Okay, on,
Desmond Limbrick. Should be on the second page, I think. We said someone on mine.
Yep, it's bottom of the first. You know what, this, I've got 2 dockets. I've got an old docket and a new docket.
Okay, well, Mr. Limbrick, as we're doing paperwork, it's gonna be
Okay. Christopher Broughton. That's, is it Cole? Giles? It looks. Christopher Broughton. There is no answer in the courtroom. I asked the bailiff to call into the hall for Christopher Broughton. That's Miss Moore? That's your case, right? Have you talked to Giles lately?
Not lately.
Okay, that's still on the docket today, right?
That I know of, so.
What is it?
Yes, it's still on the docket.
That's the way it all is. It's may or may not happen. Christopher Broughton? Is that you? Giles Cole is representing you, right?
Sir.
Where is he?
I've been trying to contact.
You've been trying to get him today? Has he answered?
When they're done.
Okay. All right, we'll try to get him. I've got a special number. Okay, just hang out there close by. Thanks. Roger Carter? Roger.
Ready?
That's Mr. Laird, right?
Yes, sir.
Mike on Carter, announce ready.
Yes, sir.
What do you say? Christopher Hino. Oh, sorry. That's Langston.
He's here.
Chris.
He's in the back coming up.
Yeah. And?
On him.
Yeah, on him.
If you don't mind.
I don't mind.
Still trying to. That one is just like a 200 something. Can I just have one resale?
Actually, right at 300.
My bad. I'm misread it. But,
I just enjoy him, kind of. Okay.
I have my mind on right and left, which is at the top. That's the direction.
At least it's not on golf or something. How much time?
Just a normal 4 weeks.
This is the criminal district court. There's nothing normal in this one.
And I'll try to give it Mr. Harris too. Well,
Okay. We're gonna reset it for 4 weeks, okay?
That's
Langston, okay, get it reset.
Thank you. Don't see you next week.
Diosdado Perez, right?
Just
Diosdado.
Thank you.
There he is. Prohibited background. Really? On this one? I'm thinking this. Have you seen this? You've seen it. I know you've seen it.
Yeah, I've heard of this area. Watched the videos.
Oh, you've seen the video?
It's far.
I didn't see the video. Okay. It's a prohibited weapon. Is that what they said? Imbrough. Where I used to live. Growing up.
There's allegedly a destructive device, but it was more pyrotechnic.
What do you call emotion? That's but it's just not.
I know, and that, but the facts will speak for themselves in front of
This one's going to be interesting. Right.
Sure. Pyrotechnic device, Your Honor.
Oh, yes, this one? Oh, yeah. No.
Yeah, that's rude. You're the next day. You still live in the school.
All right.
Just right. Well,
apparently when he waits, they go into the car and then lock the door and wait and see what happens.
Family?
Yes. Yeah, the family. Well, you've read this.
Allegedly.
This is, and then
You'll love the video.
Video, there's nothing destroyed.
Doesn't have to be anything destroyed.
You don't have to destroy anything.
Something to be
But
destroyed.
the thing is what we want is a family that doesn't have explosive devices at the house. When we're drinking, and everybody else is sitting in the car, scared to death. Are y'all ready? Are y'all ready on this? S for Davis.
We're pleased.
And finally, I got Sheena Miller again.
That's a skill trial.
Yeah. Where's Sheena? Sheena, that's her. Yeah.
You want him to sit down?
Oh, yeah, I do. And don't light anything. Sit down in there and don't light anything.
See him, Miller? No, sit down.
Yeah, you can sit down. How many, please? You have 2 or 3?
There's one with Langston and one good at that.
Yeah, we're gonna get it. Let me just take care of this and then we'll.
Yeah, this is a trial. So
Yeah, but there's 5,000 of them. I gotta.
Nothing's changing.
I just can't remember them all.
Maybe a skipper.
I don't see any prior criminal history.
I think that one of it doesn't.
Well, what
Yeah,
happened
he's
on
still
that?
out on the horse.
So the judge muted on us here. Let me see if we can move past it a little. Nope. He muted the whole rest of that hearing. All right, let's go across the hallway back to Judge West.
Eugenius Vital. And this is 25 DCCR 1374. Mr. Vital previously was here, entered a plea of guilty to the third-degree felony offense of failure to comply with sex offender registration requirements. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Yes, Judge.
Any additions or corrections?
None of them were, Judge.
All right, Mr. Parker, you may proceed.
Your Honor, Mr. Vital, he's, as far as I understand, he's done a pretty good job reporting for the last 10 years. He's lived around here, and he's also lived in the Houston area. I think the Houston was the last place that he was registered properly. He ended up going to a place called the Wheelhouse. I know it's called the Wheelhouse.
Yes, in
in Deer Park area. He tried to register there, but he wasn't actually a resident. He was doing jobs out of there, but he was living in his car. And then when they denied him because of city ordinance, that's why he couldn't live there, city ordinance rules. Then he appealed it, and it still got denied. And then he applied. He was going back and forth between his sister's house in Beaumont and working there in Houston. And you tried to apply here in Beaumont as well on.
That's where I'm registered at Beaumont.
So where are you registered right now?
My sisters keep them folks in Beaumont.
In Beaumont.
Yes, ma'am.
And that's where you're living, and you are properly registered at this time.
And I believe he's had some issues in the past. He had a substance abuse issue. He's done well with that. I think, he's not one that just ignored what he's supposed to do. I think he's tried, which is way more than I can say for a lot of people. And we're asking the court to give him probation, Judge.
Mr. Smith?
Judge, the state's going to argue for 4 years in prison in this case. The nature of the previous aggravated sexual assault of a child, I think the facts were fairly aggravating, and he was given probation initially, wound up getting revoked when he committed a new offense, and was revoked and sent to TDC for a 30-year sentence and then a 20-year sentence. It looks like even the PSI notes that even though the criminal history is limited, the circumstances of the offenses are severe. He was given probation in the past that resulted in revocation, and looks like he does try to justify his actions in the PSI interview.
I may respond.
Hold on, I just wanted to, when did you parole out? How long have you been out?
2015.
2015. And so since 2015, there haven't been any issues with reporting and it looks like, so while you were since you've been on parole, you've also gone to ISF, correct?
Yes, ma'am.
Okay.
That's why I was still in parole. I discharged in 2022.
You did?
Yes, ma'am.
And I would just like to say that, part of his revocation was, as according to him, and I think the probation officer, was substance issues. And I think that's part of the reason why he didn't.
Well, yeah, I mean, it was revoked a year after based on a possession case. And that, I mean, I don't disagree with Mr. Smith, but the criminal history, I mean, we're talking about 1991, 1993. We've had 11 years of reporting, and the wheelhouse is somewhere. I understand you're trying to get some help and do some good things, but you understand you can't do that if you can't.
Yes, ma'am.
You have to be able to be somewhere where we know where you are.
Yes, ma'am.
And that you're properly registered.
And that's when they went and denied me out there.
Go ahead.
When they denied me out there, I talked to them. And when I came, I said, I'm just going out there and going, register, back in Beaumont. And then I was still trying to, continue, to work in the program.
Right.
Drug and court.
So are you clean now?
Yes, ma'am.
Just double check that this morning, okay? Have a seat in the jury box. I'm gonna have you drug tested this morning. Mr. Parker, you've got Regina Williams, 2 cases.
But yeah, Joe,
I'm sorry.
I haven't done any paperwork on it, but this is Miss Malfino's case. We're supposed to be providing Miss Malfino with an affidavit. We have a copy of the affidavit, but it hasn't been signed. I told her that the person needs to actually go to the DA's office to present it to him. So that's where we are. I mean, she showed the document to me today, and I'm trying to get her to get the victim to go, or not the victim, this person to go to the DA's office and sign the document in front of them. And that should resolve the case, but I can't.
Both cases?
Both.
So this is gonna be the last reset. So either they go up there and do what they've got to do. They've got to go to the district attorney's office to do that. You can't just take something for them. They have to go do it. Okay. And if they don't, then when we come back, we'll have to work something else out. All right. This will be the last one.
Don't wait till day before court because, okay, well, I'm just telling you.
Talk to them and tell them if they don't go take care of this soon, then it's going to be you having some issues here in court next time. Okay. All right. You're free to go.
Thank you, Judge.
Thank you, sir. Mr. Rojas, you got Terrence Currington, the sentencing. Terrence Currington.
Yes.
Good morning. Bond will be forfeited for non-appearance and reset at 100,000. If you can get in touch with them and get them here because it's an agreed probation, so I'll consider recalling that forfeiture if he shows up.
Thank you.
All right, we'll probably check back in with Judge West at some point. Hour 3 now of TCF Live. Let's head back up to Michigan, move into the thumb. Judge Prill in Huron County.
Number 257354 FH, time and date set for sentencing in that file. In 257355, 56, and 57, those matters are scheduled for status conference. The defendant is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Rukowski. In 7354, the defendant entered a no contest plea to criminal enterprise. This was on April 20th, 2026. Ms. Karen Everlands prepared the pre-sentence report dated June 10th of this year. Ms. Weisenbach, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions, deletions, corrections, or objections to the report other than guidance?
2 corrections.
Go ahead.
It's page 1 of evaluation and plan. I don't know how the court has organized their file. When I receive it, I structure it a little differently, but it's the pre-sentence investigation evaluation plan. And the first paragraph says he's scheduled for sentencing on July 22nd. He's scheduled for June 22nd. Okay.
We'll make that correction. That's the last line. First paragraph. Okay.
Thank you. And then page 15 of that report in the employment section, which is approximately the middle of the page, and he worked at Motor City Electric, dates, whatnot, position, and then this is rate of pay. Apparently he was making $1,500 a day, according to this report. And that is.
Where do I sign up?
Yeah, not accurate. Yep, I'm told. So, but that is not accurate, and he cannot recall what his rate of pay was at that point. So just leave that blank.
If that
It'd be better than
no,
now. Okay.
That correction will be done as well.
Yes, it's better than what's there now. With regards to the guidelines, my client and I did review those two things when I was, guessing, as attorneys do, at different stages of the case. Two things I was not aware of the severity of the Florida cases, because I cannot compare those apples and oranges. That's what Michigan Department of Corrections does. And then finally, I did not know that Florida had this, outstanding nationwide pickup that just never seems to happen. I'll comment on that again later. So that unfortunately added extra points, but as far as the rest of this review, he and I have discussed this and we have no objections with regards to the guidelines.
Right. Mr. Nunnery, anything else on what your attorney mentioned regarding it?
No, Your Honor.
And you reviewed it as well, clearly?
Yes, Your Honor.
Okay. Mr. Rakowski, any objections to the report as well?
No, Your Honor.
Thank you. Ms. Weisenbach, what would you like to say on behalf of your client before the court imposes sentence?
Thank you, Your Honor. Mr. Nunnery comes before the court 54 years old with a lifetime of ups and downs. Has had mental health issues, physical abuse, good jobs, marriage, and then there's bad times like this. His hefty record here is what causes for a hefty recommendation. It's disappointing for someone who is very smart, capable of good things. Mr. Nunnery is personable, has tremendous emotional insights. He's helpful to cellmates here and other places. He wrote me letters. And I said, write everything you need to, write me letters. So he did, and he would unpack childhood trauma. He wrote wonderful life experiences that he wanted to get recorded. It reads like a good notebook story. Moments that he treasured, and it's me, story about cats. So the divorce is complete. As I explained, my efforts at trying to give him the best grade that I could was missing Florida cases. As I explained, the Florida nationwide pickup just never seems to happen. But what it does is it dings him every time it circles back through. It's 10 points, and that's a huge dent when it comes to these grids. 5 points moves a person in and out of so I did also, when I was reviewing the PSI, try to find where I could eliminate things, but it seems like he could not make that 10-year gap rule either. I saw that there was one that was 6 years, and then I got frozen because I'm not good at math before I calculated the time between 2016 and currently it's only 9. So it would have been nice to shave some of that off as well. A person's past, at some point, it would be nice if some stuff would just get forgotten, but unfortunately, I could not be able to do that for him. With regards to restitution, I would like to continue to talk to the prosecutor. Seems like the documentation that I received at the last minute, which was maybe last week or so, is something to talk about, grounds for conversation. We haven't heard a peep from the victims. It seems there's more recovered than noted. So I would like to have a conversation with them, especially with regards to insurance, insert eye roll with regards to insurance. I'm asking the court to consider the lowest end of this. He will have some comments of his own for you that I think would like to take into consideration, right, a piece of that, then it comes from me. If I do my numbers right, his restitution is lower than $5,000 despite restitution. I have to insert eye roll. But I'd like you to consider the 84 months on the low end, which is 7 years, because then he can be able to get back to work and get on parole. That's the plan. He works, he's a worker. He doesn't make $1,500 a day, but he does make good money when he's working. So that's the court to consider that. And yes, I'm fine with something for the court. Thank you.
Mr. Nunnery, what would you like to say, sir?
I would apologize to my victims. They have the right to be secure in their personal property, and I violated that right. I'm embarrassed. And the best I can say is I am sorry, and make restitution to make sure they're whole again. I was asked for a fair sentence, and even though my record doesn't show that I deserve it, but mercy is the most I can ask for. I can make no other claim against the court than that. I had lost my job, and I would have a hard time getting back on sites with that Florida violation hanging over my head, because every time I apply, unfortunately, my career requires a background check. I had nowhere to go, and I panicked. And I reverted back to doing things that I knew were wrong, but I thought I was trying to keep my family together. Thought I was buying time where I could get back to work and deserve what little bit of family time I had.
I don't know if any of this is a good enough excuse for my actions, other than I'm sorry. Thank you. Mr. Rakowski, on behalf of the people, this is a victim's rights case as well.
It is. I'm not sure if Mr. Jackson's here. I know from talking to Detective Ford this morning, who was going to try to be here. He's one of the several victims. I would point out the defendant comes before you with 23 prior felonies, which is a lot. And then, of course, as it relates to the circumstance, I mean, Mr. Nunnery was detected because there was a theft, I believe, in the affiliate area as it related to Mr. Nunnery getting on Zillow, looking at a location where people would try to buy things, and spotted a tractor. So he went up there and taken it. And then there was a tracker, apparently, a family member put a tracker on the vehicle, and that's how they found him, was based on the information of the tracker. And then all these other circumstances. It's not just, this is one and only theft of an item. It's multiple items through multiple counties, and I know he's going to have to deal with that through other areas. I would point out that Mr. Jackson, he had purchased the tractor from the defendant just a couple days, I think, prior to him being apprehended. He gave him $8,500 for that. So that's going to be restitution for there. But when the police had come in contact with the defendant, they had located $8,500 in $100 bills on him. And so we're asking the court to order the return of that money to that victim, Mr. Jackson, for the restitution, because he had just paid for that tractor. As far as the recommendations, the pre-sentence report, the guideline range is 84 months to 210 months, and the recommendation is 120, which is towards the low end of the guidelines. We believe under the circumstances it's appropriate, and we ask that the court adopt the recommendations as set forth.
When well, let me back up a bit. The court essentially, when there was a vacancy in the district court, the probate court, covered the swearing of the warrant in this case and the district court action, and eventually here in circuit court. And so I've been aware of this case since it was brought from the sheriff's department here. And the amount of property involved, the amount of victims involved, was a bit mind-boggling. An individual 54 years of age who prior to this was a lineman, if I recall correctly. And let's be honest, when the power goes out, there's no better hero than a lineman working to get our power restored, and how difficult of a job that is. And I understand that it can lead to some pretty good pay, but at the end of the day, it's very risky, it's very dangerous, and all that was lost, essentially, based upon the history of Mr. Nunnery, as mentioned, the 23 prior felonies. So the good side of this, obviously, we had someone who was working, doing the right thing. But on the flip side, to be a victim here in this case would be just frankly sad. Your own hard work, your equipment, your devices, whatever you may have, tractors, whatever they may be, all of a sudden gone. And wondering what in the world's going on. And Mr. Nunnery has to be held accountable for what he's done. He appears to display genuine remorse in this matter. However, as I've stated before, and I've stated a few times over the course of my career on the bench, you have to pay the piper here. You have to be held accountable for your actions. And the midpoint in this guideline range is actually 147 months. The high end is 210 months. And the recommendation here is toward the lower end of the guidelines. It's certainly not low when you consider the TRV level. But under the circumstances, I think the recommendation is appropriate. and as a result, the court is going to adopt it in part. It will be the sentence of this court. The defendant pay a crime victim's assessment fee of $130. Attorney fees are waived. $68 in state costs will be ordered. Restitution will be left open. However, a wage assignment is to be executed to pay restitution if the defendant is employed and misses 2 regularly scheduled payments. The $8,500, Mr. Rakowski, is that in the possession of the sheriff's office currently?
I believe it's in possession of the law enforcement. I'm not sure if it's the sheriff's department here or where it was picked up. I just know that Detective Ford had contacted me this morning, said we have $8,500 and in $100 bills. I think that is also key, is the payment was made, $8,500 and $100 bills. What was recovered was $8,500 and $100 bills.
And that'd be payable to Mr. Jackson then?
Randall Jackson. Yes, sir.
To the extent that the court can order, after obviously the appellate process has ended, return the $8,500 to Mr. Randall, the court will order that as well. Otherwise, restitution will remain open. It'll allow Ms. Weisenbach the opportunity to speak with the prosecution moving forward as to how the remainder of the restitution is addressed. But finally, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission, placed in their custody for a period of 10 years to a maximum of 40 years, credit for 258 days served. The sentence is toward the lower end, but it's a high sentence, but it's based upon the PRV level, prior record variance. And the court has to consider the guidelines, and only consider the guidelines. The court has considered the guidelines, but the circumstances here find that the guidelines are not only sufficiently scored, but at the end of the day, administer justice. By duty to inform the defendant his right to seek leave to appeal if he's financially able to provide counsel of his own choice. The court will assign counsel form of public expense. He's to initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court. Assuming the companion files pursuant to the plea agreement are addressed now.
Yes, Your Honor, they have been.
All the courts in receipt of those, the court will execute.
Okay, thank you.
Thank you.
Alrighty, friends. Coming up in the final half hour of TCF Live for this fine Monday. I hope you've all enjoyed the show so far. In keeping with this channel's promise of 9 to 11% more Judge Boyd, let's go to Judge Boyd.
Versus Mia Hurtado. Could I have parties announced?
Laura's the stage.
James Tochi for Ms. Hurtado, Judge.
And are you Ms. Hurtado?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court would find that the state is in compliance with discovery. Ms. Hurtado, did you review the application for community supervision or deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest detention with a vehicle as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
If the court were to grant your application for deferred adjudication, if your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's $1,000 fine to be probated. State recommends deferred adjudication. Taking in consideration 2025 CC 011563 and 2025 CC 012999. Did you understand that to be your plea?
Yes, ma'am.
State defense?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be the MRT, TAP evaluation, and 100 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No problem.
State any evidence?
Yes, sir. State of State's Exhibit 1 and all attachments.
Without objection, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Anything you wish to say on behalf of your client?
Yes, Judge, actually, there's a few things I need to make you aware of. The first thing is, Mia lives in Uvalde County.
Mhm.
Her plan is to remain on supervision here in Bear and not have it transferred. We kind of talked about that and she thinks it's going to work out better for her. So I don't know if the court needs to allow her to reside in Uvalde, but that is where she resides currently, but she wants the probation to remain here.
Then she will have to stay here.
Okay, well, that's why I brought it up. So then I guess then we're gonna have to ask the court to allow her supervision to be transferred to Uvalde, because that is where she will be residing. And I told her it could be transferred back, I suppose, at some point. That's item 1. Item 2 is, Mia's 28. She lives with her grandparents in Uvalde. She has 2 minor children, 8 and 2. One of them is autistic. She doesn't work. She doesn't go to school. She's basically a full-time caregiver for her autistic child. And so the reason I bring that up is with regard to the community service, I don't know if the court has any flexibility on that. Mia literally is the only person that currently is and can care for that 2-year-old. Her grandparents cannot handle him. He's a lot. And so she's just kind of watching her kids right now, and that's her life.
So who was taking care of her child when she was committing this offense in Bear County?
They were with their father.
I'm sorry?
They were with their father.
All right, so we have the father who can help out.
He lives in San Antonio. They have no custody orders. They do have an agreement. They abide by it on weekends.
Mhm.
And yes, thank God he's there to help. But the primary custodial parent is her. So I'm just bringing this to the court's attention. The court can do with it whatever the court wants.
No,
But
I will.
That's her life, Judge.
So why didn't you just pull over?
I'm sorry.
Why didn't you just pull over when the officers asked you to?
I did pull over.
Then why we're here for an evading? Because according to the stipulations that I read, they asked for your license, you wouldn't give it, and then you took off.
No, I just didn't have my license on me, but I did give my driver's license number verbally.
You're here for an evading arrest detention in a vehicle. That means that you were in a vehicle. The officers stopped you or tried to stop you, and you took off. That's why we're here. We're not here just for not turning over the license. We're here because you took off. So why?
Because I was scared.
Mhm.
It was trying to like break my window, and I just got scared.
All right, there's no mention of a breaking of a window in here or trying to break a window.
I wasn't there, Judge.
That's not in the stipulated evidence. So when's the last time you were employed?
25 January.
All right, so that means that she can work again. Because I require everyone to have employment. Are you receiving any type of government assistance with regards to your special needs child?
No.
Okay. All right. And this Timothy person in the police reports, is that the father of your child?
Yes, ma'am.
Okay. All right. This is what the court is going to do. There's $1,000 fine that will be probated. Regular reporting by Zoom or in person. Regular UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. No driving without proof of a valid driver's license and insurance. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, 50 hours will be deemed satisfied. The remaining 50 hours will be deducted upon completion of MRT. There are to be field visits one time per month for 3 months. If Uvalde does that. There's to be a transfer to Uvalde. 2 years deferred adjudication. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? With regards to this probation, if something comes up or you need help with something, you need to let probation know. You understand?
Yes.
All right, good luck to you.
Thank you.
You. Who else?
Lopez, page 6, 4 down.
Geraldo Lopez. All right, Deputy, could you make an announcement?
I already did, Judge, he's not out there.
All right, the court is calling 2026 CR 0079096 and 2026 CR 007376. State versus Gerardo Lopez. Can I have parties? Ah, he's here. Oh,
And we'd like to confer, Your Honor.
all right, thank you.
Video, you're here?
All right, who's next?
Not too much. This is gonna be on page 6.
All right, thank you. All right, probation, there's no application on this case. Court is calling 2026 CR 00743, State versus Anthony Palomo. Can I have parties approach and announce for the record?
State. Roberto Vargas for the defendant, ready to proceed, Your Honor?
And are you Mr. Palomo? Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Palomo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah, Judge.
Mr. Palomo, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Palomo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. And this is to run concurrent with 2026 CR 002453. Has he already been sentenced in that case?
Yes, Your Honor.
All right. Did you understand that to be your plea?
Yes, ma'am.
State defense?
Yes, Judge. Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Judge, you say exhibit number 1, including all time. No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client accepts responsibility. We respectfully ask that the court accept the agreement we have with the state.
All right, why do you keep stealing?
It's,
Do you like enjoy being locked up?
no, ma'am.
Then you need to stop stealing. You know, don't take what doesn't belong to you. All right, the court will find you guilty. The court will sentence you to 1 year in the state jail facility. Give you credit for any time served. This is run concurrent with 2026 CR 002453. And there's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
What is that with minors? What is that? Yeah.
All right, did you review that document with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, Your Honor. May I have the excuse?
Anyone else ready?
Alrighty, friends, let's stay in Texas but head east back to Judge West.
Good morning. Are you Davontre Johnson?
Yes.
And this is 25 DCCR 0438. Mr. Johnson is charged with failure to comply with sex offender registration requirement. And what is the announcement?
Judge, notes on Ms. French's file show that there is a new fair to register case that's in intake right now. So she has withdrawn the 5-year cap offer that she made.
Okay.
So we request a reset.
So that
for
one
the new
should,
case again.
okay. But it's already there and it can get taken care of before that next court date, I'm sure.
Yeah.
If you'll make sure they know. So what I'll do is I'm going to reset your case about 30 days. It sounds like there is a new charge that could be indicted between now and then. Stay in touch with Mr. Lewis so that he can then get the information on that one, get a new offer from Ms. French, and we'll see where we are at the next court date. All right, you're free to go. Mr. Paget, you have Catherine Bautista.
I thought paperwork, Your Honor, just said Baker's desk.
Okay, I'll call it in just a second.
You don't mind.
Mr. Samuel and Deanna Paul,
I just had her wait outside and visit with prosecutors.
I'll hold it.
Thank you. Yes.
So do I need to call this one? What is it? Says there's that from
Just to let you know, and at this time, that's, I came, right, just to let you know, it has. This time.
like make and then check mine too. May check my phone. Okay, gotcha. Oh, no, that's fine.
Marvin David.
All right, well, she's between contestants. Let's head back to Judge Boyd because she has a contestant approaching that has a very interesting choice of shirts for court.
How you doing, Your Honor?
Going okay, how's it going?
Good, good.
Yeah. Happy Father's Day.
Oh, thank you. I had the best father. My daughter had a baby 27 days ago, our third grandchild, so I got to spend the afternoon with that kid.
Oh, that is awesome.
Yeah.
Yeah, I called my mom and wished her a happy Father's Day. I'm like, you fulfill both roles, so
Yeah.
happy Father's
That's
Day.
right.
And to all the fathers who are actually doing,
Yeah.
fulfilling their obligation.
Yeah, well, my daughter got a good guy. He's a good dad.
Oh, that is awesome.
Yeah, yeah,
Well, if he's not, let us know.
yeah, yeah. We'll sick him on you, or you on him. Yeah.
All right, the court is calling 2026 CR 004915 State versus Abigail Barraza. Can I have parties announced?
Dwight Chumley for Miss Barraza.
And are you Miss Barraza?
Yes.
Counsel, you received all discovery. Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Ms. Barraza, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your? Oh, sorry, just 1 second. Did you review the true bill of indictment with your attorney? Did you understand it and sign it? Counsel, I'm sorry, not sign the indictment, but you reviewed it. Counsel, do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented? All right, Ms. Barraza, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with driving while intoxicated with a child younger than 15 years of age. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in a state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, yes, Your Honor.
Ms. Barraza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine, and the state is recommending community supervision. Did you understand that to be the plea? State defense?
Yes,
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand any such motions?
no, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years, 10 days in the Bexar County Jail, TAP evaluation, 200 hours community service restitution, DWI intervention, VIP panel. VIP. Condition of no driving, scram device for half the term, parenting classes, 2-year driver's license suspension. Did you understand those were recommendations from the state? The court does not have to follow those recommendations. Now, with regards to the 10 days in the Bexar County Jail, any objections to her serving that on GPS? All right. And then to the offense, how do you plead? Guilty. State any evidence?
Sheet of receipts, exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client is sole parent of 4 children. She feels horrible about this. I've had her mother's here today with her, and they're discussing her care for her substance use, and she's all in. Whatever you would like her to do, she's willing to do, Your Honor. She loves those kids a lot, and I don't know, addiction's a tough thing to come to grips with, and I think she's learned her lesson and is willing to get help and do whatever is necessary. Also, Your Honor, she maintains a separate residence from her mother. And her mother's car has an interlock device on it. But the mother needs to sell the car. And she's not using it. She doesn't have access to it because they don't live together anymore. So I was just, if we could just do like she's gonna be on a scram device. I don't know how that works in involving, try her driving a car, but if there's any other way we can do it so that her mother can sell the vehicle.
Yeah. Are you employed?
No, not gonna do.
So who do you live with?
Myself, my kids, or my mom.
All right, so how do you support yourself financially if you're,
I just,
all right, and how old are you?
27.
All right, so you've got to start supporting yourself and supporting your children. You understand? And how far did you go in school?
In school?
How far did you go in school?
I went to college. I have a dental assistant.
So what are you planning on doing with the rest of your life?
I want to go back into, since I already missed my, for dental assisting, I already missed it. I need to go back and take a test again so I can go back and to do that.
All right, so when are you going to do that?
This year.
All right, because people have plans to do things and then you look up and 10 years have passed and you still haven't done anything. Okay? So how often do you drink?
I was drinking before, but since the accident, I stopped.
All right. And how did you stop? Are you in any type of program or you just said, hey?
No, I was, yes.
What program?
While I was on probation, I was doing I was taking my weekly UAs, and then I was doing also some of the classes I have started.
All right, so you were on probation where?
Here, misdemeanor DW, yeah.
Ah, so now I understand why people are asking for what they're asking for. This is what you have to realize, and I know you're probably remorseful about all of this, but so much could have happened while you were passed out. One, somebody could have came along and taken your children, and you wake up, your children are all gone. Two, you could have been driving, you could have hit somebody and killed somebody, or either killed your children. Your attorney will tell you, I don't think I have ever, or he's ever run into somebody who's charged with intoxication manslaughter who said, you know what, my plan today is to get intoxicated, drive and kill somebody. That's never usually the case. Usually it's you get intoxicated, you don't realize you're intoxicated, and you drive and you kill somebody, and then you're crying, and then you're looking at major prison time. So you're one of those people who cannot drink at all because you don't know when to stop, and you cannot stop. You understand? All right, this is what the court is going to do. Court is finding you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years, regular reporting by Zoom or in person, regular UAs, make sure she's tested for ethanol, and we'll do a referral to felony drug court.
Okay, Your Honor.
There's going to be 200 hours of community service restitution. 100 hours will be deemed satisfied if you obtain your certification for dental hygienist or whatever you want to do, okay? So you can either get your certification or you can do that 100 hours. The remaining hours will be deducted 1 hour for every sober support meeting that is completed. So here's your choice. You can do 10 days in the Bexar County Jail, which would start today, or either you can do 10 days full GPS. That means 10 days full GPS. That means you can't leave your house. You're just at home for 10 days. Or if you're employed, or if you need to go to the grocery store or do something of that nature, I will give you 20 days partial GPS, and you'll have a window of when you can take care of any type of personal needs. So which?
Yeah, 20.
All right, so there's going to be 20 days partial GPS. Pick a day, pick a time.
Yeah, to get it hooked up, you need.
No. I mean, what day? It's going to be partial. So what day will she need to run her errands? She'll get 1 day.
Oh, 1 day, okay, during the week. Yeah.
I guess on Tuesday.
Okay.
All right, so Tuesday, She's allowed to be out of her home from what time?
In the morning, so by 7:30.
All right, 7:30 a.m. to, let's be reasonable.
Yeah, like 4 in the afternoon. or something.
All right, 7 a.m. to 4:30 p.m. on Tuesdays. Waive GPS fees. DWI intervention. VIP live. There's to be no driving. Removal of ignition interlock. Scram device in exchange for the ignition interlock. And that's to be half the term. And there's to be an affidavit of non-driving as well. There's to be a TAP evaluation out of custody. So felony drug court will probably accept you if you're honest with them. If you're not honest with them, they're not going to accept you. And what will end up happening, a TAP evaluation will take place, and whatever the recommendation of TAP, that's the recommendation that's going to be followed. Parenting classes. And 2-year license suspension. Probation. With regards to the parenting classes, let's do this. So she'll have 50 hours deducted if she obtains the certification from community service restitution, and then another 50 hours deducted upon completion of parenting classes, and then the remaining 100 hours, 1 hour for each sober support meeting completed. And there'll be field visits 1 time per month for 3 months. Probation, is there anything else? Thank you. Proof of employment within 45 days. No employment as a home healthcare provider with minors. Probation, make that 60 days since she's going to be on the GPS. So proof of employment within 60 days. Is there anything else, probation? Okay. Anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so here's the thing. You probably have your group of friends, right? If you are out and you're trying to tell your friends you're trying to maintain your sobriety, and they're not helping you with that, maybe they're drinking in front of you. You may have to tell them, hey, at this point in my sobriety journey, I can't be around people who are drinking. If they still want to drink, then they're not your friends. You understand? Yes. If there's something you need, be sure and let probation know about it, okay? Yes. And get a sponsor.
Yes, with AA. Yeah.
All right, good luck to you.
All right. Permission to recall one?
On what?
She had a existing.
Yes. All right, the warrant will be recalled.
Thank you, Judge.
Can you give me that cause number again so I can put it in the system?
Yes, sir.
Okie dokie, friends, that will do it for today, though rumor has it that In the Blind with Mike and Dan makes its triumphant return this evening at 7 p.m. Eastern, 4 p.m. Pacific, so you might want to check that out. Just a recommendation. Other than that, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. The wisdom I leave you with today comes from a certain man named Samuel Clemens, a.k.a. Mark Twain. Courage is resistance to fear, mastery of fear, not absence of fear. All right, my friends, it has been fun. Thank you so much for spending time with me. We'll see you soon. Take care. God bless.